next week.
Why? What is the urgency?
Urgency as because by virtue of the appellate order and the defendants are trying to dispose and next two.
Supplementary list item number 1.
Item number 14 has become infructuous.
Item 14 dismissed as infructuous. Senior counsel appearing for the petitioner submits that the matter has become infructuous by effects of time. Hence, the petition is dismissed as infructuous.
He has got all the credit.
Yes.
Item
Item 1, yes.
1, in the staff reporter has pointed out the delay as 2 days.
Yes.
To my estimation, there is no delay. However, I will have to file an application.
You have to file an application.
Right.
All right. Steps for limitation be taken within a week. Within a week or what? Within a week. List this matter. Vacation for Nova for list this matter. What did it call? Huh? Weekly list special?
We commencing 15th July.
Week commencing 15th July. Yes.
Item number 2.
I am the wife, files the TRPC for transfer of the CP case number 109, which is filed by my husband. And I am being tortured and deserted, and the criminal case also, intercept, are also pending. And I want it from Bhadrak. I am residing in my parental house, interior in Dhamnagar, the district of Bhadrak.
Bhadrak to Baleswar, what? No, rather Baleswar to Bhadrak. Why? Why?
Constant threat and indigent. I can't move
No.
without security.
No.
And
No.
prior to that,
Bhadrak to
he has
Baleswar.
tortured, and I have had page 3 months.
Yes.
On 31/12/23, OP husband assaulted the petitioner and administered poison in cold drink, who is undergoing treatment in serious condition at a medical college.
So lodge an FIR.
This is the conduct. I already that.
So that was the law.
and medical report is also.
No, that is no ground for
This
transfer.
is the conduct of my husband.
No. This is no ground for transfer.
And the indigent person, I can't. I am dependent upon my.
No.
clean
Baleswar to
parents.
Bhadrak is 70 kilometers. What is the nothing?
Still, it is interior from Bhadrak.
No.
Kind.
No. I can permit you to move an application to appear virtually, and your physical presence will not be insisted upon on every day. That order can be used. The petitioner, being the wife of opposite party, seeks transfer of CP number 109 of 2024, pending in the Court of Learned Judge, Family Court, Baleswar, to the Court of Learned Judge, Family Court, Bhadrak. Stop. Said petition has been filed. Said proceeding has been initiated. Said application has been filed under Section 13 of the Hindu Marriage Act for a decree of divorce by the husband. It is submitted that the petitioner has been residing with her parents, as she has no means of sustenance. Further, the distance between her house and Baleswar is 125 kilometers, for which it would be difficult for her to attend to the court on the date of posting of the case. Stop. After considering the submissions and the grounds raised for grounds cited for transfer of the proceeding, this court is of the view that the same cannot be treated as valid grounds, particularly when facilities for appearance through virtual mode is available. In such view of the matter, I am not inclined to allow the prayer for transfer. Stop. The transfer application is therefore dismissed. It shall, however, be open to the petitioner to move the concerned court seeking permission to appear through virtual mode, which, needless to mention, shall be considered in accordance with law. Next. The court below shall also not insist upon the personal attendance of the petitioner unless it is absolutely necessary. Yes.
Item number 3.
Please allow.
For this, regarding the transfer of an arbitration appeal application, if your lordship should come to page 14,
Page 14.
the order by the learned district judge.
Yes.
Because his father was the scribe of the award, so who had passed the award. So he cannot hear this matter. So he had passed an order that he will be writing to the High Court for transferring the case. But neither that has been done nor the Lord.
Has he mentioned-
railways have filed the appeal, they have not taken any step.
Has he filed any, has he mentioned it in his order?
Yes.
Where
Your
is
lordships, page 14.
Yes.
Your lordships must see the order dated 12/12/2023.
12, yes. This offers that the award has been passed by sole arbitrator Dr. Niranjan Nayak, appointed by them, who is my father. So where can we transfer it?
That your lordship, because railway, their councillor are also here, Katak and also Union of India, but anyway, subject to your lordship, sir.
No, but you have to serve a copy unless you, to pass.
No,
the-
I have served
As a
copies,
final order.
I'll serve another copy, that's not a problem.
All right. So this opposite party number one,
It's not necessary to be noted just because it is his order, so that's why, because of the personal reason.
there is no
And it
deputy
is
registrar.
judicial.
There is no post of deputy registrar.
And, that
There
is
is no
what it
post
has
of
been.
deputy- देखिए code लिखा है इस- There cannot be any deputy registrar post. There is only a registrar. Registrar civil courts. You
I'll
delete it. Better.
I'll delete.
You delete the part.
I'll delete.
Sri D.P. Nanda, learned senior counsel with
Mrs. Maharana. S. Maharana.
Mrs. S. Maharana. Request for permission to delete the opposite party number one. Permission is granted. Learned counsel for the petitioner is permitted to make necessary correction to the cost title in the court. 2 extra copies of the transfer application be served upon any of the panel advocates of Union of India by tomorrow. You can take it up. I'll pass an interim order, so let it come after vacation.
Interim order is not required.
Not required. You have filed an IA?
No, that was
Oh,
for
dispensing
the
with it.
dispensing with the certificate that we have obtained in the.
So we'll take it up in the reopening day, on the reopening day.
As you know.
List this matter on 19th April. I mean 19th June.
19.
Yes.
Hon'Ble.
Item number 4.
May I please your lordship, the petitioner seeking direction for transfer the MLT case of 19 of 2024 from the family court Balangir to the family court Hon'Ble.
Why? On what ground?
Lordship,
On what ground?
Your lordship, the petitioner having a small baby of 2.5-year-old and she's a working lady serving as a junior revenue assistant in the district welfare office Hon'Ble.
Yes.
And the distance is also 130 kilometer and
What is the husband doing?
the husband is also
Yes.
see he lived in our local area Balangir and
No, what does he do? What is his profession? You said about your profession. What is the profession of your husband? Yes. What do you guys know? You're not thorough with the
I have
facts.
no instruction, your lordship.
What
actually.
instruction? Why are you filing this petition without instruction? Why are you moving it? If you are not prepared, you are submitting what is your profession before the court.
Yes.
Can you not anticipate that the court will also ask what is the profession of the husband? So that the court can pass an order considering he may also be a government servant.
Kindly one pass over, your lordship.
Pass over.
Item number 5.
What do you guys do again? Yes.
The petitioner is seeking transfer of the CP case number 6/24 pending before the families of Nabarangpur filed under section 13 of the Hindu Marriage Act
Nabarangpur
by the
to
husband to the court of the families of Jaipur, Korapur on the ground there is a distance of more than 55 kilometers and 2 minors on
distance is 44 kilometers.
2 minors 55 kilometers.
44.
two minors on Mylar, annexure one Mylar. 7 years and 12 years are prosecuting studying in Jaipur Mylar. Third Mylar, they are the OP and his elder sister, who is a practicing lawyer at Nabarangpur, he has threatening for which FIR was lodged by annexure 3 Mylar.
Well, I take notice
Yes,
Also
Mylar.
notice.
Case 22 Mylar.
to the opposite party number 2. Why state of Odisha is a party?
Yes.
Why state of Odisha is a party?
Because yes, some other court was directed to make a status.
No. Well, anyway, issue notice to the opposite party number 2 by speed post, fixing a short returnable date, requisites be filed by tomorrow. Let's this matter on
3rd July.
3rd July. In the meantime, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having due regard to the date of hearing of this case. Yes.
Item number 6.
Relating to disengagement of the petitioner for the post of the Anganwadi helper.
On the post of Anganwadi helper.
Yes, my lord.
This matter was yesterday.
Yes,
Did you examine?
yes.
Yes.
This is the sub-collector who is the appellate authority. He is
Supplement
also
the appellate authority.
That appeal also pending before.
So we'll direct him to consider the appeal.
Of 2023.
The new guidelines.
Yes. 2F,
Yes.
the last page.
Direct provision is there.
Yes,
The petitioner has approached this court seeking the following relief. The case of the petitioner is that he was engaged as Anganwadi helper. Koutha se jagata? In Putuga.
In the center of Putuga,
In the Putuga Anganwadi Center.
my lord. District of Keonjhar.
By order dated 19/1/2024 of the CDPO Joda. Stop. While working as such, she was served with an order dated 7/2/2024 passed by the CDPO Joda, directing her disengagement from service. Being aggrieved, the petitioner has approached the sub-collector by filing an appeal on 26/2/2024. It is submitted that said appeal is pending. So this court finds that as per revised guidelines for selection of Anganwadi workers / mini Anganwadi workers / Anganwadi helpers, the sub-collector is the first appellate authority for hearing complaints regarding selection / disengagement of Anganwadi helpers for all projects. As per paragraph 2, bracket small f of the guidelines for selection of Anganwadi helper. Since an appeal has already been preferred from the appellate authority being the sub-collector, Champua shall do well to consider and dispose of the same in accordance with law as early as possible, preferably within a period of 2 months from the date of production of certified copy of this order. Yes.
Item number 7.
And the petitioner was appointed as Gonsikek, my lord, and claiming backdated from regularization. Dhananjay the case, my lordship has party.
Same order can be passed.
Both the cases are rejected.
Same order must be.
Item number 8.
Yes.
May I please? RO stands recorded in the name of Golapalli Dandasai.
Is an RSA.
Sorry.
Is an RSA.
Yes, RS.
Against a confirming or reversing judgment.
Modified. RO stands recorded in the name of Golapalli Dandasai Patro. He had 2 sons, Radha Mohan Patra and Purnachandra Patro. Golapalli Dandasai Patro in the year 1964 partition the successory property between his two sons. And in the partition deed, it has been categorically stated that in order to pay back the loan, categorically stated that loan filed over the joint family is to be paid back by G. Radha Mohan Patra against the property that is allotted to him through partition. Categorically stated, because Radha Mohan Patra is the elder son. So whatever loan is there, family loan, it has to be paid back through this partition share. And this certified copy is marked as Exhibit 3 in the court below. In order to clear the loan, he compelled to sell the property on his behalf and on behalf of his 3 minor sons.
No, who are you? Are you the plaintiff or the defendant?
I'm appellant, plaintiff.
You are the plaintiff. So you
Plaintiff.
filed a suit for declaration.
Plaintiff.
You filed a suit for declaration that you are the absolute owner in possession and enjoyment of the suit land, and to record the suit land in their names.
Sons, 3 minor sons are the respondents. Then in the sale deed,
No. This is second appeal. This is a second appeal. So you have to first say the status of the parties. Who are they? What is the genealogy? What is the relationship between the plaintiff and the defendants? Then we can go to the dispute. You have straight away gone to the dispute. So the court will never understand. So the plaintiffs, who are the plaintiffs?
plaintiffs of the subsequent purchaser,
Subsequent purchase.
subsequent purchasers,
All right.
and 3
So
minor
many,
sons.
so seven plaintiffs are there. All belong to the same family.
Yes,
All right. Then who are the defendants?
a minor son, 3 minor sons, and the legal.
Minor son.
Means after attaining majority, they have appeared in the.
Anyway, but the names do not tally. This is Kamini Nahak, Sashikanta Nahak.
Wife of,
They are all Golapalli, Divakar Patra and not. So
we are the subsequent purchaser. Kamini Nahak is the wife of elder son, and the defendants were the
elder son of whom?
wife of subsequent purchaser.
Do you have a genealogy, madam? Have you prepared a genealogy?
I'm coming to, please. I'm coming to.
No, it's all right. But this is a second appeal. How will the court understand the?
Make clear. So in the sale deed, it has been categorically stated that in order to paying loan.
No,
This is the sale deed.
Who sold to whom?
The father,
The suit property. You are talking about the suit property.
suit property.
All right. You are the
Father-
subsequent purchaser.
Subsequent purchaser.
Yes.
Father, in order to pay back the loan, has sold the property, his behalf and on behalf of 3 sons, 3 minor sons, to one Ginni Maharana, Ginni Arama. And in the sale deed, it has been categorically stated that in order to pay the urban bank loan, the sale deed has been executed, and to maintain the family, to manage the family, it has been categorically stated. And that certified copy has been marked as Exhibit 4, the sale deed. It has been categorically stated. Paying back loan. So, from the date of purchase, since 1966, Ginni Arama, she is in peaceful possession of the suit property. And the white RST number 130 by 1975. It has been marked as Exhibit 4 in the court below. Then Ginni Arama in the year 1975 sold the property to Jamuna Nahak. Jamuna Nahak is a predecessor of the present appellant. So until her death, she peacefully possessed the suit property. And after her death, the present appellant, being her successor, they possess the suit property till date. To finding of the in the year 2019, the present appellant sought a crop loan that was denied because ROR doesn't stand in their name. So they issued a notice to the collector. The collector though received the notice, but no corrective measures were taken. So they filed a suit. So in the court below, they filed a suit for declaration that they are the absolute owner in possession and enjoyment of the suit property. And for a direction to Tahsildar Kunsi to record the suit land in their name and consequential benefits. At page 42, learned court below, finding is that.
Come to the issues first. Let us see the issues first. Come to page 37.
42, the court.
All right. First, come to the issues. This is a civil case. You have to go step by step, isn't it? You have read the brief. I have not read the brief. So how will I understand? You come to this. What was the point of dispute between the before the court below? That the court has to see, so that one can appreciate what was the decision.
In the written statement,
Come to issues. I'll understand whether the suit is material, whether the plaintiffs have got any cause of action to file the suit, whether the plaintiffs are absolute or not in possession, whether the plaintiffs entitled direct decision of further. So issue number 3 and 4 are more important. The most important thing. All right, and 3 and 4 he has taken up together.
yes,
Let us see what is the finding.
that by judgment and decree declared that we are absolute owner. The plaintiff is an absolute owner of the suit-suitable property along with right title interest of the same. Our bearing number 130 by 1975 of Khajuria Moja is valid and binding, and the defendant number 5, Tahsildar Khonsi, is directed to record the suit led in favor of the plaintiff.
So the suit was decreed.
Decreed.
Then they carried it in appeal.
Appeal. In
Appeal.
appeal, they have never stated about that alleged co-personary right. Even in the written statement also, the defendant never stated. Till date, we are in possession. But with the impugned finding, it's at page 61. Being the ancestral property of G. Radha Mohan Patra, then his minor son have acquired co-personal right at the time of execution of sale deed in the year 1966. So my humble submission is that
So this is a reversing judgment.
modified.
What modified?
Modified that 1/4 we are entitled to 1/4 share
So that is reversing. That will be reversing. That will be treated as reversing. So your share has been confined to the share
of father.
of the father. Yes, 1/4 share.
So my humble
So what is wrong in it? What is wrong?
I'm coming, sir.
Yes.
My humble submission is that before the written statement as well as in the appeal, they have never prayed for that alleged co-personality right. So it is a settled and binding precedent that an issue not properly raised in the pleadings or during the issue framing stage of trial would not be permitted to be agitated for the first time at the stage of appeal. The scope of a suit is limited by prayers made, averment made out in the plaint, and the defense put up by the defendants in the written statement. A claim not made cannot be decided by a court. So my first substantial question of law is that whether the appellate court has not made as in the staff, it's page 15. My first substantial question of law is that whether it is not misadventurous on the part of the first appellate court to traverse beyond its virus by arbitrarily bringing in the issue of co-personary interest of 3 minor sons in the suit-suitable property, which is neither specifically pleaded in the written statement nor paid for in the appeal by the defendant appellants in the court below.
All right.
That is my first substantial question of
That is all. That's all.
And in the impugned order, they said that in the year 19 impugned finding, they have said that
All right.
admittedly they
All right, madam. All right. I'm admitting it. Heard you are Mrs. Kanungo. Full name?
Madhusmita Kanungo.
Heard Mrs. Madhusmita Kanungo, learned counsel appearing for the appellants. Peruse the impugned judgments. Stop. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. 1. Whether the first appellate court was correct in deciding the issue of co-personary interest of the minor sons of the defendants in this in respect of this suit schedule property without any specific pleading in this regard by the defendants in their written statement and without any issue being framed consequently. Satik.
And my second substantial question of law is that in the impugned findings, they said that father and 3 minor sons. Succession Act just says that as long as father is alive, the children will have not share. So how after father,
गोटे से हेले बाकी सब तक आपण रेज कर परिबे.
Four होची Articles 60 of 1963 limitation.
Limitation can always be raised. A substantial question of law need not be framed, and even if it is not framed, also you can raise. All the points can be taken up. All right. Issue
And
notice.
to IA,
Wait. Issue notice to the respondents by registered post. Returnable within 4 weeks. The requisites be filed within 3 working days. Call for the LCR. List this matter on
Convention.
Huh?
Convention 29th July.
29 July. What you have filed this
IA to stay the judgment and decree of the appellate court and to not to create third party interest and to maintain status quo.
status quo as on date with regard to the suit property shall be maintained till the next step. Ira karo IA. Dita ka IA record di. Yes. केवे कॉले लिस्ट दिस मैटर केवे कॉले
Was 29th July.
we commencing 29 July. Yes.
Item number 9.
Dita record so and record karo. Hoy gote order hobo. Mr. Das,
My lord.
you have 5 minutes.
State
You have 5
I
minutes.
more minutes and to show the documents only.
No, other thing, you were not there yesterday. Yesterday, I have given a proposal to Mr.
Yes,
Swami.
yes,
That today-
I have a submission. If my lord is keeping it to.
No, I have without argument. I have heard it. So it will be fresh in my mind. Don't worry. You don't have to make any argument on that day.
ସେଇ ଦିନକୁ ଆର୍ଗୁମେଣ୍ଟ ମୋର ତାହେଲେ ଥାଉ ସେଇ ଦିନ କହିଦେବେ 5 ମିନିଟ୍ ସେଇ ଦିନ ବି କହିଦେବି ଆଜି କାହିଁ ସେଦିନ ମୋର ଟିକେ ରିଫ୍ରେଶ ହେଇଯିବ ଆପଣଙ୍କୁ ରିଫ୍ରେଶ କରିଦେବି ଆପଣ ଏତେ ବ୍ୟସ୍ତ ଭିତରେ ଭୁଲି ଯାଇପାରନ୍ତି ତ ମୁଁ କାହିଁ ମନେ ରଖିବି ସେଇଦିନ
ମାନେ ମୁଁ ଭୁଲିବିନି ସହଜରେ ଯେ ମୋର ଲେଖା ଅଛି ମୁଁ ସହଜରେ ଭୁଲିବିନି।
ଗୋଟେ ଯୋଉ ଏଇଟା ମୋର କହିଥିଲା ଗୋଟେ ଭଲ ହେଇଥିଲା
ନା, ନା।
ସେଦିନକୁ
State
ଷ୍ଟେଟ୍
Your Lordship may close it today. And
State
do it
is
for
for some-
filing of written note, it will be
State
posted on 20.
No, that will not be proper. That will not be
State-
proper.
As your Lordship said.
State council has not submitted. Let them submit so that I can give a reply.
And the state
They have not
council
stated.
will coil in it.
We have nothing to say beyond the findings of the.
Yesterday I had asked them.
Yes, if they decline, then I will give a reply on the reply.
No, you can give a reply. You can, but today it was fixed for your reply today. But because of it will not be possible to pass a
ସେଇଥିପାଇଁ ତ
judgment.
ମୁଁ କହୁଛି ଆଜି କାହିଁ ମୁଁ କହିବି ମୁଁ ଟିକେ ରଖିକି ଉପର ଛୁଟି ପରେ କହିବି ଏକା କଥା I am ready to
All
that. There is nothing new to be add.
All right. As requested by Sri S.K. Das, list this matter on 18th. No, ଆମର କେବେ ହଉଛି 19th.
19 ତାରିଖ
19th. 19th June. No, MB karo. Heard further arguments in part.
Yes.
Heard further arguments in part. List this matter on 19th June. Right. So only just refresh.
I have my notes of the
Yes. And you can also give your note on that.
I will give.
That would be easy.
Item number 10.
This matter where Mr. Patnaik had to submit those documents.
Yesterday he did not come.
Yesterday he was there.
Huh.
Then
He said probably after lunch or something like
after
that.
lunch, your lordship said that it's not possible to keep it to today. So may I just make a very humble submission? May I just place my case, my lord?
Please.
Otherwise,
I cannot.
but this
If you,
keeps on.
I mean, this is not fair. If you ask time from the court and the court grants you, you are supposed to be present.
I've also filed a small note.
Yes.
But before that, my lord, let me just place this case. Because the petitioner's case, my lord, is that he was appointed on 1/1/1980.
Mr. Patnaik is there. Yes.
Petitioner's case, my lord, is that he was appointed as a PET
Yes.
with on 1/1/1987, and he joined in the services on 5/1/1987. He continued as such, my lords, and in the year 1992, all of a sudden, the management, my lord, they refused to allow him to sign the register, my lords. Then he made a grievance before the director. The director, my lords,
When was it? When was it?
no, the annexure 1, my lords,
Annex 1.
at page 21, my lords. It's 11/2/1994.
He's not allowed to sign in the staff attendance from November 92. But he files it in 94.
94. That was entertained.
That is beyond 30 days.
No, that was entertained.
As per that 83 circular.
True, my lords. That was entertained.
Anyway,
That was entertained, and since no action was taken by the annexure 2, I'll just quickly run through the
yes.
annexure so that your lordship will get the idea, my lords. Again, my lords, I represented the deputy director on 28/3/1995. There's annexure 2, my lords, making that grievance, my lords. Then, my lords, notices have issued by annexure 3 at page 24, my lords. to the Secretary Governing Body for hearing of the appeal of the petition of the and it was fixed for 5/7/1995 at 11 a.m. That was Annexure 3 at page 24.
Yes,
Then my lord, this was heard, and your lordship may permit me to place that minutes.
this order.
That order minutes.
Yes, yes.
Annexure 4 at page 25 minutes. Appeal petition of Sri Rangadhar Paikare, who is the present petitioner. Minutes.
Yes.
Fact of the case. There is dispute with regard to the appointment of PET in Kaptipada College, Nuasai, in the district of Mayurbhanj.
It is Koptipada.
Sorry, Kaptipada. I'm sorry. Since the college does not permit the petitioner to sign the attendance register from November 1992, the present appeal has been preferred. The detailed facts are as under. The detailed facts are as under. The college is said to have appointed one Sri Rangadhar Paikare as PET on 5/1/1987 by issuing an appointment letter issued by the Secretary of the Governing Body on 1/1/87. Sri Paikare was having HSC qualification at the time of his entry into the service. He acquired CPA qualification in December 1987. The college has furnished his name in the staff list on 13/5/89 as HSC CPA qualification. The college is said to have appointed another man in the name of Sri S.K. Mahanti as PET and shown him in the staff list furnished on 7/11/1987. Strangely enough, the college has again said to have appointed one Sri R.K. Mahakud on 23/10/1986 and has shown him in the staff list furnished on 21/7/1993. As per the report of the principal, he acquired CPA qualification in the year 1990. Lordship, just mark the dates. Though there are variations of records and disputes regarding the posting of the PET in the college, the records furnished by the college at different times amply prove that Sri Paikare was in the employment of the college as PET with effect from 1/1/87. Though his appointment letter produced at the time of hearing does not bear dispatch number of the college. It is pertinent to mention here that the appointment secretary of the GE who attended governing body who appointed the hearing admitted that the appointment letter produced by Sri Paikare bears the signature of his predecessor. Along with Sri Paikare, though the college has appointed two other PETs in the name of Sri S.K. Mahanti and Sri R.K. Mahakud, as per the statement furnished, the records indicate that Sri Paikare has passed CPA in 1987 and Sri Mahakud has passed CPA in 1990. There is no record to the effect that Sri Mahanti has passed CPA. Though, as per the records furnished by the college, Sri Mahakud has joined the college earlier than Sri Paikare. The latter has acquired the professional qualification CPA, which is required for the post earlier than Sri Mahakud. Then the judgment is for the foregoing facts conclusively prove that Sri Paikare is the first qualified PET joining the college. Hence, he is to be reckoned as such. This order was not complied with, for which, my lord, this particular order, I came to this honorable court, notes. And the management as well as opposite party number 6, who is Mr. Mahakud, they also filed 2 writ petitions. Now, all these 3 writ petitions, they were heard and this order was set aside and it was again sent back to the DPA, director. What happened, my lord, in the directorate level, one person heard it, he never passed that order. Thus, his incumbent in office passed that order, for which I had to file another writ petition, that is Annexure 5, that is 9868 of 2008.
Yes.
And in that, my lords, the order was set aside at page 30, if your lordship would see. Last paragraph. I need not take your lordship to the entire thing.
No,
Last paragraph. In order to know the truth and genuineness of the allegation of the petitioner, we call for the record from the Director of Higher Education pertaining to the aforesaid matter. On verification of the record produced today, we find there is some truth in the allegation of the petitioner, as the incumbent who passed the order on 11/6/2008 was not the same officer who heard the matter on 15/1/2008, and therefore it is conclusively proved that the impugned order has been passed without hearing the petitioner. Accordingly, we set aside the order dated 11/6/2008 passed by the Director of Higher Education, Odisha, in Annexure 8 and direct him to rehear the matter and pass appropriate order after giving opportunity of hearing to the concerned parties. Let the petitioner opposite party number 4 and 6 appear before the director on 25/9/2008 with the certified copy of this order, on production of which the director shall fix a date of hearing and conclude the same within a period of 1 month hereafter. Learned counsel for the petitioner submits that he shall bring certain facts to the notice of the director for which the record of the appeal which was disposed of on 24/11/1998 was necessary. If such an application is filed by the petitioner praying to call for the records, the director shall call for the same. The petitioner disposed of accordingly. I filed a petition, my lords, and those records of the earlier director's order was never not called for, not produced. And your lordship would appreciate that the documents which I wanted to place before the director, which he could have come, Lord, I have placed that memo. These are the annexures, my lord, which I have placed, my lord, memo of appearance. Then if your lordship would see, before the director, I, my lord, file an application by annexure 6 for calling for the records.
Annexure 6 is not.
Page 33.
Okay, okay.
So that is an application calling for the records of appeal petition. Also so and so.
The earlier appeal which you had filed.
My lords, because that is the leave which was also granted by me before this Hon'Ble Court, because that contained certain annexures relating to the appointment of present opposite party number 6, remark.
But he must be maintaining one single file. It's an appeal which
Lord,
was, the order was set aside
unfortunately, my lord,
it has been remanded, so it has to be one
it
file.
was not done, my lords. Unfortunately, it was not done.
Every time a new file was opened.
Maybe, my lords. Then, my lords, I filed an application as a written note at the annexure 7 series, enclosing, my lord, these annexures, my lords. If your lordship would kindly see.
Yes.
I need not bother your lordships. Page 40, I had prayed for this. Then, my lords, page 41. My lords, I say that this is my appointment letter.
Order. Yes.
Appointment letter, which says that Rangadhar Paikare, son of Sri so-and-so of village so-and-so, P.S. Kharia, is hereby appointed as PET +2 in the scale of pay of the 935. So-and-so, so-and-so, he is directed to report to the undersigned on or before 5/1/87, failing which the appointment order shall be treated as cancelled. Then, my lords, I join, my lords, regarding this on 5/11/1991. Then, my lords, what has happened, my lords? A clarification was sought for regarding appointment of Sri Paikra PET in Kaptipada College. That is in the second round of litigation, my lords. And this ex-secretary Kaptipada, my lord, he replies on 11/2/24 to the director. My lord, just as requested by Sri Paikra, it is clarified that during my period holding the office of the governing body of the Kaptipada College, Nuasahi, as secretary, I appointed Sri Paikra PET +2 in the college by appointment letter dated 1/1/87. The appointment letter was issued after GB resolutions in that regard. It is pertinent to mention here that at the time of appointment, he was the only qualified candidate having requisite qualification for the post like BSc Ed, and accordingly appointed letter was issued directly to him to join on or before 5/1/87. Sri Paikra submitted his joining report in due time, which was subsequently accepted by the GB, confirming his appointment. During my period of his service as PET +2 in the college was very much satisfactory, as reported by Sri Paikra, that the existing principal is not allowing him to sign in the staff attendance from November 1992, disputing his appointment is a matter to be decided by you conducting personal visit to the college. In the premises, it is therefore requested that the service protection may be given to Sri Paikra, who has been validly appointed and was serving in the college minutes. This was a clarification given on 11/2/1994 to the director, my lords. Then, my lords, again, my lords, Sri Paikra writes that it will be necessary to give me service protection. It's not very relevant, my lords. Then your lordship would kindly see again, there's another thing that reiterating my stand before the directors of Sri Paikra, my lords. That is also not very relevant. Then your lordship would see that I have also annexed the earlier order of the director before the second sitting or second stint, my lords. Then, which I had already placed before your lordships. Then your lordship would see, along with that, the documents which I had filed was regarding Ramakrishna Mahakur's appointment. Your lordship would kindly see, my lord. Application for the post of PET. This is given by Ramakrishna Mahakur. Sir, I came to know from a reliable source that the post of PET is lying vacant in your college. I offer my candidature for the said post. As my educational qualification, I have passed IA examination in the year 1989. I am competent in sports and games, trying to pass CPED training very shortly. Therefore, I pray you to consider my case and appoint me as PT of the college and oblige. He says he passes the IA examination 1989 and he writes this letter on 20th of October 86 minutes. And this very letter is also there in the counter, my lords. So this is what I wanted to bring to the knowledge of the director, my lords. Then, my lords, the second letter, my lords. Sri Ramakrishna Mahakut, your lordship, what is it? Ramakrishna Mahakut, son of Sri Maheshwar Mahakut, so and so, and hereby appointed as it's a blank, and in the usual scale of play blank. His appointment is purely temporary and on ad hoc basis, subject to approval of the next GB meeting. The service can be terminated at any time without notice or without assigning any reason. He is directed to report to the undersigned on or before 11/5/86. Your lordship would kindly mind. He makes an letter on 20th of October 86 saying that I have passed my IA in 89. Then he is appointed when he is asked to join on 11/5/86. Failing which his appointment is to be treated as cancelled, no TSO and so will be given, and the GB Kaptipada College dated 30th of October 1986. Lords, this, my lords, again, my lords, he, as per this letter, he files his joining report supposedly on 15/11/86. He says request for acceptance of joining report. With due reference to your appointment so and so, I joined at so and so AM on 15/11/86 in the office of the college. And if your lordship would kindly see the attendance register, my lords, which is at page 51. Even though he joins on 15th, he started signing from 3rd.
But
4th.
this is Sarath Kumar Mahathi.
No, no.
51 at page 51.
This is Lord Mahakut, Lord. The lordship would see
At page 51.
At page 51, Lord.
No, proper lekha is.
Sir, at the right hand column, Lord. Sir,
Okay. That is not very visible.
My lord.
All right.
It contains a signature both. Your lordship got it, Ramakant Mahakut.
Yes.
He started signing it from 3rd. 3rd, 4th, 5th he signs. Then he continues to sign, and from 15th onwards he signs it. So prior to his appointment, he keeps on signing the attendance register. And that is a stand also taken by them. They say that, my lords, he was allowed to sign the attendance register, then acquaintance roll, everything and all that. Then your lordship would kindly see, my lords. I again make an application for calling for record. That was never done. And that is how, by annexure 10, my lords, the impugned order happens to be passed. This is 25/6/2009.
Let us see the impugned order.
Date of final hearing is 21/11/2008. And he passes his order, my lords, on 25/6/2009. I may just place this impugned order, my lords. Pursuant to the order dated 19/9/2008 passed by the Honorable High Court in WPC number so and so, the aforesaid matter was taken up for re-hearing on 20/10/2008. The case was fixed pursuant to filing of memo by the advocate on behalf of the opposite party number 4 and 6 on 25/9/2008 as directed by the Honorable High Court. Similarly, the petitioner also filed a memo of appearance on so and so. On 20/10/2008, the matter was heard partly and both the parties were directed to exchange the copies of records between them by 24/10/2008 and to submit the relevant records before the Director Higher Education Odisha within the said date. Further, both the parties were directed to appear before the Director Higher Education Orissa on 15/11/2008. Ultimately, the matter was finally heard on 21/11/2008 from both the parties and on the basis of records, the written submissions furnished by them. On bare perusal of the records and written submissions and taking into consideration of the Director order under Annexure 5 to the written submission, that's the earlier order of the Director.
98 order.
My lords. Filed by the petitioner, it is found that the appointment of the petitioner, Sri Rangadhar Paikre, said to have been appointed on 5/1/87 is very much doubtful because the ex-secretary of the college, while issuing the clarification, I also read that clarification to your lordships, regarding his appointment of Sri Gangadhar Paikare under Annexure 2 has stated that at the time of appointment, Sri Paikare was the qualified candidate having the requisite qualification for the post like BA CPA. Such appointment letter was issued after GB resolution. Assuming that Sri Paikare was appointed on 5/1/87, at the time of appointment, he had no CPA qualification for which he was untrained. He acquired only CPA qualification on 15/12/87. Moreover, the appointment letter is having no dispatch number of the GB or the GB resolution does not speak about the approval of appointment of Sri Paikare against the post of PET of the Petitioners College. Therefore, from the structure of appointment letter and from the clarification of the ex-secretary dated 11/2/1994, there is no prima facie to believe that the appointment is genuine. No prima facie, he denies it, Lord. He says there's no prima facie reason to believe in this appointment.
Actually, he means to write no prima facie.
No prima facie case is made out for appointment, whatever. It's not happily worded.
Yes, yes.
On the other hand, as is evident from the records submitted by the college, that once Sri Ramakrishna Mahakud was appointed by the GB and got appointment by letter number 25 dated 30/10/86, and he joined against the post on 15/11/86, which was approved by the GB on 24/11/86. At the time of appointment, Sri Mahakud was untrained PET and was permitted by the GB to go for PET training to acquire CPA qualification by resolution dated 2/9/89. The Lordship may kindly mark me also. I was the only trained person available in 87 months. He obtained CPA certificate during the year 1990. The attendance register and the acquaintance roll clearly indicate about the bona fides of Sri Mahakud as PET of this college, whereas the GB resolution attendance acquaintance do not speak about Sri Paikare as he was appointed as PET of that college. The observation made in para 7 of under Annexure 5, that is the first order of the director, if it is examined, then definitely Sri Mahakud is senior to Sri Paikare as per government circular number so and so dated 6/10/88, where the date of joining is the yardstick to decide the inter se seniority in the same grade. Therefore, the balance of judgment lies more in favor of Sri Mahakud, who has joined with effect from 15/11/86. Hence, the case of the petitioner is disposed of accordingly. This is how, my lords, I price the present writ application. And your lordships have issued notices on that. Lord, in the notice, my lord, on order dated 10/1/2011, in miscase number 16166 of 2009, your lordship would, they have clarified, this honorable court has clarified that any payment shall be subject to the result of the writ petition. Miscase number 16166 of 2009.
Order dated?
Order dated 10/1/2011. Lordship court.
No, any release, that is 16166 of 2010.
16166 of 2010. I'm sorry.
Any release of the salary to opposite party number 6 shall be subject to the result of the writ petition.
And then this matter has come up. In this writ petition, my lords.
So the management, you are appearing both for the management as well as the opposite party number 6.
All right. The management, my lord, I'll take the counter filed by the management. That your lordship would get perhaps at page 62, if I'm correct.
Yes.
Running page 62, my lords. Lordship.
Yes.
Paragraph 3, my lords.
No, before you do that, Mr. Kora, I would, I need not tell you this certiorari. A factual finding has been given, unless you show that it is perverse.
It's perverse because
that is what I want you to focus on this point.
My lords,
But that finding is perverse.
that is why, my lord, I'm taking a
Otherwise, why this court will?
Your lordship has taken that stand that they say that such a person, so far as the college is concerned at Kattipada, he is non-existent. That is the basis on which they, or the premise on which they proceed. Notes.
That this Paikra person was never appointed.
He was never appointed.
All right.
And they failed to recognize that such a person was existing.
Only if you are able to demonstrate from the available materials and record.
I'll be making a humble effort, my lord, in that.
That is what I just want you
So,
to.
your lordship would see. I'll just place quickly.
Otherwise, I will not go into all those.
No, your lordship need not go, my lord.
Yes.
I'll just quickly place paragraph 3, which according to paragraph 3, my lord, at page 62.
Yes.
I'll quickly place it, my lords.
I am not completing it today.
As your lordship insists. As your
Keep
lordship.
it to the reopening day for reply by Mr. Patnaik.
Manage.
Because otherwise, I'll have to.
Subject to change of assignment again.
On that day, at least, it will not change.
May
change thereafter.
I'll just quickly place, my lord, sir, that in respect of the amendments made in paragraph 1, point B, this deponent humbly submits that the opposite party number 6 applied for the post of PET in the college on 20-10-1986, having been selected on 21-10-1986. He was appointed on 30-10-1986, and he joined as PET on 15-11-86. Furthermore, he applied for study leave on 29-4-1989 for CPA training. He was granted study leave by resolution number so and so dated 2/9/89 for CPA qualifications, which he acquired to have passed on 12-11-1990. So they recognize, my lord, that he is, by the time of his appointment, he did not have the requisite qualification as CPA. And it's a fact, my lord, that I have, my lord, acquired that qualification in the year 1987.
Yes.
And he resumed his working by joining in the previous post. The lordship.
Yes.
And he resumed his work by joining in his previous post after training on 7/7/90. The lordship may see the contradiction.
Yes.
They say they completed his training on 12/11/1990, but he said that after training on 7/7/90 against the said +2 college. Thus, the opposite party says Ramakrishna Mahakur is the only PET of the college. He has been continuing as PET in +2 Kaptipada College, so and so. And the application so and so, study leave of so and so, GB resolution so and so, Annex A/7. It is pertinent to mention here that the opposite party number 6, Mahakur, has been signing the staff attendance register. Your lordship might marked it. He is appointed on 15th. He starts signing from 3rd. Acquaintance register, and has been legally continuing as PET against the +2 college with effect from 15/11/1986. Where the petitioner has neither been given appointment letter nor he has been discharging his college duty as PET of the +2 college, nor he has signed the attendance register minutes. The advancement so and so has never been appointed, so and so that they denied. Then your lordship may see, my lords, that the amendments made in paragraph 3.2, 3.3 are not correct in view of the fact above. Since the petitioner was never appointed as a PET of the college by the competent authority, the question of refusing him to, from November 1992 to sign the attendance register, that is after 5 years of service, does not arise. The petitioner has neither been appointed nor signed the teacher attendance register at all. Then a lordship may come to paragraph 7. Till date, Lord, they deny the fact of existence of high crime. But paragraph 7 at page 64, your lordship may kindly see that the amendments made in para 3.5 and 3.6 are not correct. The opposite party number 4 appeared before the DPI in pursuance of the notice of the DPI and had submitted the written statement denying the fact of the petitioner's appointment in +2 college as PET post. The college authorities had intended, your lordship may kindly see, the college authority had intended to help to the petitioner in the event the +2 and +3 degree college are bifurcated and the petitioner may be adjusted in the +3 college. However, the DPI, without taking into consideration the real fact and law, allowed the appeal on 24/11/1995, but the same was quashed on so and so by this honorable court to so and so, so and so. Then your lordship would see that they say that in order to help me, they have shown it. And if your lordship would kindly see, now the annex, lords, page 7, I have already taken the lordship to that, where he says that I passed my, at page 68, I passed my IA in 89, and this is a letter which is giving on 28/10/86. They also annex the same letter which I have done, lords. Then in the next page, the lordship would see This is a request for study leave.
Page
This is
number?
also interesting.
Page number?
Page number 69. Annex A by 4 series, my lord.
Yes.
I've been selected to undergo, Your Lordship, I've been selected to undergo CPA training at Baliapal College of Physical Education from July 1989. This is an essential training for me. I'll join in my present duty soon after completion of the training. Therefore, I pray to grant me study leave for July 89 to May 1990 and allow me to rejoin after completion of my study leave, and obliged. This he gives, my lords, on 29/4/1989. Then, unfortunately, my lords, as per the resolution, which they have also annexed, and I have also taken your lordships to the other one, he gets relieved, he's allowed, my lord, at page 71. This prostava, last prostava, my lords.
Yes.
This ninth line from the top, my lords, of that prostava,
Yes.
your lordship would see, Ethipai AK August 89, Ruth Bosomas. Your lordship get that word, my lord? 9 lines from the top, my lords. At least 1, 2, 3.
The top page row.
Top row or the last row, say paragraph last to 4th line.
नहीं मतलब नवम प्रस्ताव
Again, नवम प्रस्ताव.
श्री रामकृष्ण महाकोड को
Again. Tara just the 3rd line, 4th line from the bottom.
Yes.
Your lordship would see that AK August 89.
छुट्टी देवा पे
Again, AK August 89. Then your lordship would see the director, Lord, this is interesting, reading page 72B by 4. In the second round, my lord, the principal of the college, my lord, he was, my lord, asked to give a detailed report. This is a report submitted by the principal, Kapipoda College, Nuasai Maribhanj, my lords. I'll be humbly praying, my lord, I place this at.
Please.
Before the learned director, Higher Education Odisha, clarification of the learned DPI's objection in respect of 2 points raised in his letter dated so-and-so, letter number so-and-so, 19/8/895. In pursuance of the letter number so-and-so dated 19/8/895, I am to inform you that Sri Ramakrishna Mahakut has been appointed as PET on 30/10/86. His appointment has been confirmed by GB Resolution number 5 or dated 12/11/86, and in pursuance to the appointment letter issued on 30/10/86, he joined on 15/11/86. He has been continuing as such till date. He had gone on a study leave for acquiring CPA qualification from July 1989 to May 1990. The GB, my lord, they allow him from 1st of August, but the principal rights, my lord, he has been allowed from July 89 to May 89. Furthermore, the entire fact is corroborated by attendance register, acquaintance register, and all other necessary documents of this college. Now, this paragraph is important. On the other hand, the name of Rangadhar Paik Rai, whose qualification is IACPA, your lordship may kindly mark it, appears in certain documents, indicates the fact that he had joined on 1/12/1988. This fact of joining is imaginary, and such was mentioned in the letter. That is, it's not very visible, my lord. Data so-and-so sent to the DPA. Sorry?
It is in certain records sent to DPI.
It's certain record, DPI, Office of the CHSC. Your lordship may kindly mark it.
Yes.
It's because of the oral instruction of the then Secretary, Sri Nirmal Chandra Mahakut. And he had given this instruction, keeping in mind that the junior most will be appointed and adjusted in the +3 college in future, when +3 college will be opened. In other words, the secretary wanted that his name may be recorded in some places, that is Paik Rai's name, in some places, and he has not
as he has
not been given appointment letter. Appointment letter at all. Even though Sri R. Mahakut has been appointed earlier and has been continuing in the +2 college till date, his name was not sent in the staff position because he had not acquired CPA qualification, which he required acquired, sorry, in the year 1990. Your Lordship may kindly just mark it. I've been made a scapegoat and a sacrificial lamb, my lords. My names are sent to all places because I am a trained person, my lords. And Mahakud, my lord, he is shadowed all the time because he did not have the requisite qualification till 1990.
Yes.
And the problem began, my lord, after Mahakud acquired his qualification in 1990, when I was refused, my lord, to sign education on 5/7/1996 because Sri Paikre was never been appointed by the governing body. There is no appointment letter issued to him, and he has never joined on 1/12/88. His name, your lordship may kindly mark, his name has only been sent to accommodate him in the +3 college in future. The secretary has made this arrangement to fulfill the present and future requirements of +2 and +3 college, and also to satisfy both the persons of the same locality where the college is situated. It is about that mere sending of name does not give him right to the post held by another person legally and lawfully. Furthermore, I like to submit that there is no malified intention. After all this, my lord, he says there's no malified intention, and anybody else in giving appointment to of Sri Mahakud as PET and sending the name of Sri Paikrai in place of Sri Mahakud as PET. So they say that there's no malifiers attached, that you appoint someone, send the name to the CHSC and other authorities of the government, my lords. There's no malifiers, according to them, my lords. This has been done. Sorry, this has been done under the compelling circumstances and with noble purposes. But I'm sorry, my lord, sir.
Unfortunately.
But unfortunately, Paikra has misused the goodwill shown by the secretary to him by approaching the Honorable DPI. So this is, my lord, the letter of the principal addressed to the DPI, my lords, saying, my lords, the various facts. And he says, my lord, even though we have sent the name of Sri Paikra, we have not given him appointment. And we have sent the name of Mahakud after he has acquired the trained graduate qualification. And this was done without any malifiers, only for the noble purpose of accommodating Sri Paikra in future. And they, my lords, take cognizance of the fact, my lord, that on the date of appointment, they also say I was IACP'd. The principal, my lord, he also says that I was an IACP'd, my lords. So I was trained, I was in the college, my names were sent to various authorities, my lords, and the problem arose, my lords, after 1990 when Mahakud acquired his trained graduate qualification.
But if you were there in the college, apart from the appointment letter which you are showing, you must have been paid.
Because at that time, the block grant had not come. The block grant came in 1990.
Maybe, but how were you paid?
But nothing, Lord. It was all gratuitous. I was not paid at all. Because your lordship could see they have also said that Mahakud for the first time was paid in 1990 when the block grant was granted. And by 1990, since he had already acquired that qualification, his name was sent for the block grant. Thereafter, the grant in aid came. And interestingly, my lords, Mahakud was a party in this case. Notices were sent. He took an order from this court to consider his representation in view of a particular decision, and grant in aid was released in his favor, suppressing the fact that he's a party here. And the interim orders of this honorable court that everything would be subject to the result of the writ petition.
Yeah, that interim order is there.
Well, that interim order is there. But if your lordship would call for that records, my lord, I have grave doubts whether he has declared this pendency of this writ petition.
I will call for it.
Well,
That's all.
and that is once I'll just take the the counter of Sri Mahakud. That
Yes.
No, that is then opposite party number 6, Sri Mahakud's affidavit starts on page 80, my lords. Then, my lord, he said, I have joined and he has applied to the honorable courts. Then, my lords, at page 81, if the Lordship would kindly see. Paragraph 2, my lords.
Yes.
That the opposite party number 6, having stood first in the interview, was selected, approved, appointed, joined, and finally permitted to go for CPA courts on 21/10/1986, 12/11/1986, and 2/9/1989. And after the course was completed, he is resumed his duty, my lords. His appointment, my lord, is 20/10/1986. And before that, on the very next day, he says that I've gone for training. 21/10/86, he has gone for training. Again, 15/11 ତାର appointment ହେଲା, ସିଏ କହିଲାଣି ଆଜ୍ଞା 21/10/86 ରେ ମୁଁ ଯାଇଥିଲି training ଲାଗି, 12/11/86 ରେ I had also gone for training, and 2/9/1989, when he was permitted by the governing body to go, he has mentioned that I've gone. So he has mentioned 3 dates. Then your lordship would see that he has mentioned that about this grant in aid order and the writ petition which he has filed is 9844/2011 to get the benefit of the grant in aid order, paragraph 3, and that's how he gets it, my lords. Then your lordship would kindly turn to page 83, my lords. At the cost of repetition, my lord, just last 2 lines at page 82. However, my lords, page 82, sir.
Yes.
Last 2 lines. However, it is admitted and undisputed fact that the opposite party number 6, having been legally and lawfully appointed since 30/10/1986 as PET of the college and after following the due procedure of law, has been continuing with the benefits of grant in aid order 1994 till date. On the other hand, the petitioner has not been appointed in place of this opposite party number 6. It is further admitted fact that the petitioner has not been appointed on 1/1/1987. It is further a fact that his false and fabricated appointment is not against vacant post, as this opposite party number 6 has been appointed as PET and continuing as such with effect on 30/10/1986 against Kaptipur +2 college, where he is the only where there's only one post of PET. Then, my lords, the rest of it is not necessary, my lords. Then your lordship would kindly then my lords, he gives his appointment letter at page 87. Then page 88, he gives his joining letter, my lord, dated 15/11/86. Then he gives the resolution, my lords, which are dated 24/12/1986. Which allows him, my lord, to complete at page 91 that within 4 years he has to complete his CPA training, my lords. Then the resolution which I had already shown, my lords, on 2nd of August 1989, where he was allowed, my lords, on 2nd of August. He gives 3 dates in his first way, but he was allowed by the GB to go on 1st of August 89. Then, my lords, your lordship would kindly see the interesting turn comes in 94, page 94. While, my lord, this was sent for this block grant 3970. Ramakrishna Mahakul, you got it, notes? He was shown as a physical education teacher. First, his date of birth so and so. Date of appointment is 30/10/1986. They have shown it, and this was sent to the director for this grant in aid order of 89 minutes. 2009 minutes. Then, my lords, this is the annexure C/6 is the order which he gets where the Honorable Court depends on Professor Sou's case and allows his grant in aid application for grant in aid. And he's after this thereafter subsequently he receives it. And he has given at page 100 his grant in aid orders where he has
well, this is consequential.
Well, and thereafter, my lord, the rest of it is all on records, my lord, and the higher education thing which they recognize him at serial number 21, page 105.
But then, as I had pointed out at the very beginning,
Sir,
more than the weakness in his case, you have to stand on the strength of your own case.
Correct, sir.
So you have shown a particular order of appointment,
So,
but you say that you were never remunerated.
my,
So there's no question of having your name in the acquittance roll.
right.
So that would have been a great proof. Now, how will this court come to a finding that
No.
you were appointed and
My lord, your lordship would appreciate a person is not appointed, but he is kept as a leave reserve officer. His name is being used. So far as the recognition of the college is concerned, it is being sent to the CHSC. It is being sent.
where is that document?
No, they have admitted.
They have admitted.
They have
They have
admitted
admitted,
that.
but I would like to see the document. Is it?
But I had called for those documents. Unfortunately, my lords, if your lordship would kindly appreciate my application, lord, at page 12, my lord, of the writ petition, I've said that please produce all these three documents.
That is all right. That's all right.
These three documents were never produced. So indirectly, my lord, that's why, my lord, indirectly, I'm trying to emphasize on the point that my name was sent to the CHSC, my lord. If your lordship would see paragraph 3.12,
We can ask the management to produce that document.
my lords, they can do it.
Yes,
Because
sir.
I have asked for the document relating to the examination duty for the year 89-90 and 1991. I have asked for the staff position list sent to CHSC in the year 1988-89, which they say that they have sent my name because Mahakud was not trained. And it was sent for a noble purpose to keep my name as a reserve.
Even assuming such a stand
My lord,
to be correct,
my lords.
will it confer any right on you?
Not
That is the
conferring the right of me, my lords, to the limited extent, my lord, if my humble submission, that they acknowledge the fact that in 87, I was trained, IA trained, the other person was untrained.
So you could have been appointed, but
My lords, and
after he acquired his training, he was appointed ahead of you.
he acquired his training in 1990,
True. But he at that point of time,
my lords.
if there was a choice before the management to appoint, make an appointment
Between both of us,
yes, then
I should have been selected because my names till 1990 were being sent to various authorities.
that I think you should have challenged that inaction at that point of time, Mr. CORAM.
But, your lordship would see my predicament. I approached the director. I asked him, please call for the records. Those records were not called for. Fortunately,
We'll ask the government. We'll ask the government to produce. Yes, Mr. Patnaik.
Yes, sir.
He produced. If his name was included in the staff list, which was sent every year for renewal of recognition, it must be available with the government or CHSC. CHSC probably they have a different council.
Well,
But I think the government can always produce it.
thing is that, my lord, because this matter was remanded to the director to take a decision after this, my lord, after giving chance of hearing to both parties. So opportunity was given to provide all kind of documents and to exchange all the documents.
No,
Before utilizing
he
this-
files an application, the director doesn't pass any order on that.
Pardon me.
He files an application. That
Yes.
copy of that application is on record.
Yes,
But and that has been permitted by this court, the divisional bench. And the director doesn't pass an order.
with respect to asking for the appeal file, my lord,
Yes,
of the previous appeal file.
yes.
But after exchanging the documents, my lord, the specific finding of the director, my lord, the same what it was earlier held, my lord, in the first instance, which was in favor of the petitioner.
No, this court would like to see, Mr. Patnaik, why, you
No,
see,
Yes,
whether his name was included in it is admitted by the management. I have seen
yes.
that it is admitted by the management that it was, as Mr. Koro has been repeatedly saying, that it is for noble purpose. They have
they
mentioned
have mentioned it noble purpose,
noble purpose.
no malafide.
କାଲି ସକାଳେ ଯଦି +3 କ୍ଲାସ ଖୋଲିବ ତମକୁ ଆମେ ସେଥିରେ ରଖିବୁ
କିନ୍ତୁ
ସେଥିପାଇଁ ତାଙ୍କ ନାଁଟା ସେମାନେ
Sir, ମୋର କିନ୍ତୁ +2 ର ଲାଗି ପଠେଇଛନ୍ତି। +2 ଲାଗି ଯେତେବେଳେ recognition ଲାଗି ହେଲା,
ଲେଖିଛନ୍ତି ସେ ଯେ +3 ଯେତେବେଳେ ଖୋଲିବ
ଖୋଲିବ କିନ୍ତୁ for the moment since you are a trained person, we are sending it to the CHSC
Where
for
is-
+2 purposes.
where is that document? I would like to see that document.
My lord,
Will it be
I have
available?
the file, my lord. I have the original file with me. And the documents which they have actually exchanged between themselves. The management, the opposite part number 6 and the petitioner. These documents are available.
No, but what about that CHSC recognition
No, that
renewal?
That not there.
ସେଇଟା ଏଠି ମଗେଇବନି?
I think, my lord, it is very much available with the management. my lord.
Management ତ definitely.
Because they were directed to produce all the original files, my lord. I think
They have.
they will fail, my lord, then I will try.
Yes, Mr. Patnaik, you have the original resolution book, acquittance roll register that you have.
I have
And the renewal recognition forms.
Those things are not there, but mainly my lords wanted to know these two things.
No, that is true, but today in course of argument,
So my lords direct the nega.
yes, yes, you go, why don't you produce that? Because management has admitted, it is not as if he's saying it out of the blue. Management has admitted that the document is there, where they say that his name was included, maybe for noble purpose, maybe for a pious,
Wish to-
sympathetic, whatever. It was there. There has been but this court would like to see the document, the renewal application form, which will contain the list of staff teaching, non-teaching, समस्त detail थियो, along with the dates of appointment and everything. It's a statutory form, in fact.
Consider
ଆଜ୍ଞା ସେ ଯୋଉ recognition ଲାଗି ନିଶ୍ଚିତ ଗୋଟେ statutory form
It is a form, it is a form.
ସେଟା ତାଙ୍କର staff list ଟା
Alright.
ଦେବେ ତାଙ୍କର
Alright. Heard Sri Rudra Prasad Karal and senior counsel appearing for the petitioner with
Mr. Himanshu, Mr. Rai's powers there also. Ain Rai.
yes,
Mr. Ain Rai and Himanshu.
anybody, Mr. N. Rao. In course of hearing, Sri Karo has drawn attention of the court to the admission made by the management before the director that the name of the petitioner was included in the list of staff sent for renewal of recognition to the CHSC in the year 1990,
88-89.
in the year 1988-89. This court would like to peruse
And
said recognition, renewal of recognition form. Sri B.K. Patnaik, learned counsel appearing for the managing committee, is requested to produce the said forms for perusal of the court. 1988-89.
and also below the conduct of examination duty in the year 89-90 and 1991.
Sri Karo further submits that the petitioner was also deputed to examination duty
My lords,
in the year
1989-90 and 1991.
Sri B.K. Patnaik is also requested to produce the document relating to deputation of staff for examination duty for the aforementioned period. List this matter on 19th June.
And my
May I
learned
remind
friend,
one thing? My lord, opposite partner 4 and 6, my lord, they have filed a counter. I may be provided with a copy. my lord.
Copies of the counter filed by the
Yeah.
opposite party numbers 4 and 6 be served upon Learned State Council.
and my learned friend for the state may produce the original records of the director's proceeding.
I have to pay.
No, the first proceeding. That's the second proceeding. The first proceeding was never, my lords.
Is it any different?
My lords, my humble submission, it is because certain
Alright,
documents were given.
I'll produce, man.
Sri Patnaik Leonard AGA is requested to produce the original file relating to
My
the
lords,
proceeding before the director,
my lords,
which was concluded on
concluded on 24/11. That's my lords annexure 5.
data ko duna to conclusion.
Sir, set up data the annexure 4 at page 25. So set up
Thiba na?
24/11/95.
Yes, 24/11/1990. Huh?
Thank you.
You produce the original
Yes.
file. Yes. All.
Item 11,
Obligements.
Merge the Utkal University printing press matter.
ଛୁଟି ପରେ ଆସୁ ଦେଖିବୁ କଣ ଆପଣ ଆଣିଛନ୍ତି?
ନାଇଁ ମତେ କଥିଲା କଣ ଦେଖିବା ପାଇଁ ବୋଲି ପ୍ରୋଭିଜନ ଟା ଯୋଉ ଷ୍ଟାଚ୍ୟୁଟ ରେ କୋଉଠି ସିଡ୍ୟୁଲ 2ଟା ଅନୁସାରେ ପ୍ରମୋସନ ଦିଆ ହବ ବୋଲି ଲେଖାହେଇଛି। ସେଟା କପିଟା ହଁ ଏଇଟା ଥାଉ ନା ଏଇଟା ଖାଲି ଦେଖିଦେଇକି ରଖିଦବ। ଆଜ୍ଞା ହାଇଲାଇଟ କରିଦେଇଛୁ ସିଡ୍ୟୁଲ 2ଟାରେ ଅନୁସାରେ ପ୍ରମୋସନ ଦିଆ ହବ।
Every trade that exists on the date of commencement of these rules with its typical channel and hierarchy of posts carrying different nomenclature is illustrated in the chart in Schedule B. If a person is recruited in a trade at the first point, he will have his promotional channel in the trade as indicated in chart in Schedule B. This Schedule C. Schedule B है proofreading.
শিডিউল বিটা হচ্ছে হায়ারার্কিটা যেটা দিয়ে চারটা।
72 ঠিক আছে ছুটি পরে আসুন further arguments in part let's this matter on 6th June 26th June বলে assignment change পাঠার তো hard further arguments in part করবে
May Premal here in this case, opposite part number 4 got promotion. He has been issued notice whether it has been made sufficient or not, and maybe check minors. Otherwise, minors because suppose minors the petitioner succeeds, then obviously minor the promotion of opposite part number 4 will be
I
cost.
think I had checked up probably let me see
Otherwise, minors in the meanwhile, whilst during vacation, it can be made sufficient.
you are applying for OP1
OP1 also we are put in university OP1 1, 2 and 3. OP4 Santosh Kumar Ratha.
all the orders have been communicated to all the opposite parties including opposite party number 4 but let us find out whether Mr. SP Mahanti and his associates appearing for the petitioner. Mala. Mr. Abhiram Samal, Learned Counsel and associates who are appearing on behalf of the petitioner is deleted. Kala. Otherwise, we'll.
Hmm?
Yeah, I was thinking otherwise we can issue another notice. Same thing, nahi. Service is sufficient on OPs 1 to 4.
1 to 4 1 to 4 লিখি দিয়েছেন দেখি দিয়ে টিকে চেক করে দেন অফিস চেক করে যদি হেই যাইতো ভালো কথা
Office লিখিছেন নোট
তাহলে আমার দরকার নেই আর দরকার
How the can? It was way back in 22/10/2019.
না তাহলে
Service is sufficient on OPs 1 to 4. Order number 2 may be seen. Order number 2 is notice due ho jayitbo. Sure sir. Ab ame tadara
না দরকার নেই
yes.
Item number 12.
26. ऐसी जो करों को केस रही करों को केस रही Learned CGC shall Mr. Maharana shall apprise the court this court as to when the writ petition filed by Sarathi Charan Sahu that is OJC number was disposed of. Yes.
That regarding disposal of the writ application of 1996, but we have in our department there is no such record we have found. And I have also checked out on the website as well as I visited the end. It shows that it is pending, but I unable to say
I call for that record. Why?
exactly. That will be better. I will also
The Maharana
show that matter is pending, not showing disposal.
The Maharana CGC informs that he has not been able to obtain the date of disposal of OJC number 2789 of 1996. And the website shows the matter to be pending. In such view of the matter, registry is directed to tag, office is directed to tag OJC number 2789 of 1996 with the present case. Place this matter on
3rd July.
3rd July.
Lordship, a short date may be assigned. Your Lordship, my learned senior has already argued and the matter has been parted. Lordship, a short date may be assigned.
Short date means?
Lordship, 20 or 21st May. Lordship.
21st May?
Yes.
No.
Your Lordship, June, July.
I said no. That is the order. Yes.
Item 13.
Obliged.
Yes, what is this matter?
Lordship, for the petition, Lordship, I filed
Regional lordship.
What is this?
Regional lordship because against the counter, open number 1 and 2 lordship.
You are filing it today?
Yes, yes.
Stamp for Vajidi. Regional কোনো স্টাম্প নেই। হবে স্টাম্পটা নম্বরটা affidavit sign is affidavit বলেছি কিন্তু অনেক কেসে মারা যায় করে কিন্তু মারা যায় I think some court fee is required on the rejoinder.
As per the rule of the
I don't know, I have forgotten, please tell me.
High Court rule lordship index and date chart everything will be.
No, index date set করা কোন this is the rejoinder you are filing.
Yes.
Affidavit রয়েছে affidavit তো আছে affidavit আপনার কোন নোটারি মারছেন
Separate affidavit lordship is there.
হ্যাঁ affidavit নোটারি কেবল মারা নোটারিয়াল স্ট্যাম্প মারা আছে বুঝলি তো কোর্ট ফি
Notary করছে affidavit আপনার
হ্যাঁ হোক পিটিশনটা কোর্ট ফি লাগা যাবনি 3 টাকা কোর্ট ফি লাগা যাবনি Yes, anybody? Yes, Mr. Pradhan. Regional দরকার নেই sure
3 টাকা 30 টাকা 3 টাকা 30 টাকা লাগবে
কোন আগে কହୁଛନ୍ତି ମୁଁ କିଛି ବୁଝି ପାରୁନି
330 ଲାଗିବ
ପାଞ୍ଚ ଟଙ୍କା 30 ଲାଗିଥିବ
ଟଙ୍କା ତ ଲାଗିବ ନା
ଲାଗିଛି
କୋଉଠି ଲାଗିଛି କି
ପଛପଟେ
affidavit ମୁଁ notarial ଟା କେବଳ ଦେଖି notarial stamp
ପଛପଟେ ଲାଗିଛି
okay
ଆଉ ସେପାରେଟ affidavit ଦିଆହଉଛି ସେ
only the affidavit bears the
adjacent 30 ଟଙ୍କା ଲାଗିବ
special edition ହଁ ଠିକ ଅଛି ତାହେଲେ ଠିକ ଅଛି କଣ ହେଇଛି ରେ so you are filing a rejoinder today your soft copy are there sir well Srimati learned counsel of the petitioner files rejoinder in the court to the counter filed by the opposite party number 1 same be kept on record then what is this a synopsis
Yes, but OP number 1 and 2. Ignesh. That is the OP number 2. And this is the OP number 1.
Srimati also files rejoinder to the counter filed by opposite party number 2 in court same be kept on record Hala? Yeah ছুটি পরে শুরু হয় এটা
Okay.
জুন মাস
হ্যাঁ জুন করো চলো list this matter on 26 too
Item number 15. Item number 15.
I am filing affidavit along with the document showing that the petitioners are senior
to one Sunil Kumar Patnaik. And it's a serving copy.
As directed, Sri Sharma, Learned Counsel, the petitioner files an additional affidavit to prove his contention that the petitioner is senior to Sunil Kumar Patnaik.
Serial number 60 and myself is serial 56.
Hey, same captain record. Copy to the
Okay, soft copy.
Yes.
So you were appointed. What is the name of the petitioner? Prakash Chandra Panigrahi and
Prakash Chandra Panigrahi. I was promoted in the year 1/9/2006. And Mr. Sunil Kumar Patnaik, serial number 60, he promoted on 31st October 2007.
yes.
This is calculated after 8 years from the date of admission post appointment.
Yes.
So accordingly, I am senior. All the petitioners are senior to Sunil Kumar Patnaik. So they are entitled for litigation of increment. Here my
Was your claim rejected?
no, not rejected.
Then approach the authorities.
No, I have approached the authority. All the annexers are there. No, kindly come to page annexer 6 series, page 38.
Yes. No, but this court cannot pass that order. It has to be passed by the authority. You have to approach the authority. But by satisfying that you are, and they have, the government has, in finance department has clarified how the accreditation of pay or stepping up of the pay is to be done.
In the counter, they have stated that that is for the government collection, not for the aided educations. But so far as order 9 rules, order 9 of the 74 rules is concerned.
Section rule 9.
Rule 9.
Parity.
Parity. This is a scientific.
I know that.
With that observation, your lordship may dispose. The taking into consideration rule 9 of 74.
Our specific stand, my lord, this is with respect to.
But you have never rejected their, you have taken in the counter, isn't it? You have never taken into account the effect of rule 9 of that 74 rules, which says that in the matter of salary, this will come under salary.
Yes.
Isn't it? Salary, DA and some other allowance.
Not this is about DA.
The pay, DA and
rule 9 of payment of dearness allowance to the petitioner has been paid to the lecturer of government college. Discussion in fact and contention held. Opposite party cannot deny payment of dearness allowance to the lecturer of aided institution like the petitioner at the rate where, then at which such allowances is being paid.
Direct provision is there.
Counterpart to the government.
Yes, direct provision is there. Right. Every employee of an aided educational institution shall draw the same pay, dearness allowance and subsistence allowance in case of suspension as is admitted. Decision of what is statute? What is your stand? What is the taken in your counter?
Yes.
Our study that is first government employee.
Page kete?
Paragraph 5, page 2 of the counter, paragraph 5.
After the introduction of the ORSP rule, my lord, a separate notification was issued by the ORSP rule was actually introduced under Article 309 of, by the Finance Department.
Yes.
Thereafter, my lord, Higher Education Department for the non-government aided college, my lord, they issued a notification in the 2009. Now, taking into consideration the concept of fixation of the pay and other things, my lord, when certain clarifications were required to be issued, Finance Department issued a clarification. Now, the petitioners are claiming the benefit of stepping up pay. It is not actually addition of increment, it is stepping up pay, my lord, at par with their junior. Basing upon that particular clarification issued by the Finance Department. And our stand is that, my lord, that that particular clarification is only applicable to that 2008 rule, which has been issued for the government colleges, and there is no such provision which has been introduced by the Higher Education Department.
But this, the statutory provision is very clear, isn't it?
Yes, ma'am.
Statutory provision is very clear. So I will direct the So let him file a representation. This will be considered in light of rule 9 and all.
Yes, ma'am.
The petitioners actually.
Petitioners.
Yes, you know.
6, no.
The petitioners have approached this court seeking the following relief. All the 7 petitioners are working as lecturers in RCM Science College, Khalikot, having been appointed on different dates. So, they have been drawing their salary components directly from the state government under the RCM scheme, under the plan scheme, as the college is an aided educational institution within the meaning of Section 3, bracket B of the Odisha Education Act. Please correct me if I'm wrong factually.
No.
As per the Odisha Revised Scale of Pay Rules 2008, the pay scale of the petitioners was revised with effect from 1/1/2006, with the next date of increment being fixed at 1/1/2007. The pay scale of one Sunil Kumar Patnaik, working as lecturer in chemistry in the said college and junior to the petitioners, was also revised with effect from 1/1/2006. However, his next date of increment was also fixed as 1/6/2006. क्या ये 1/6 केमिति आला? 1/1/2001 तर 1/6 केमिति आला? How?
The option ଦେଇଥିବେ ସେ ତାଙ୍କର date of increment ପାଇଁ.
As a result,
during fixation of pay ରେ ସେମାନେ option
as a result, the petitioners, despite being senior to said Sunil Kumar Patnaik, received less salary in view of the fixation of pay after revision. The petitioners submitted representations for stepping up of their pay to maintain parity with their junior. It is stated that despite several representations, no action was taken. Yes?
Annex 6
No action was taken. Yeah, we need not go into that. No action was taken. In the meantime, the state government, the government and finance department, right, memo number 25541 dated 2/6/2010,
yes,
issued a clarification to the effect that the pay of an employee can be stepped up or the date of increment can be antedated with that of his junior, where senior gets less pay than his junior on account of fixation of pay of the junior in ACP after availing his usual increment. So, it is the case of the petitioners that despite such clarification issued by the finance department, the grievance of the petitioners for stepping up of their pay was not addressed, for which they approached this court in the present writ application. Counter affidavit has been filed by the opposite party number 3, by Assistant Director, Regional Directorate of Education, opposite party number 3, inter alia, stating that the clarification, this is the finance department memo dated 26/2010 is meant for stepping up / antedation of pay of government employees only under ORSP Rules 2008. Right Finance Department notification number 55244 by F dated 24/12/2008. Further, there is no provision for stepping up / antedation of pay in respect of employees of non-government aided colleges by resolution dated 21/5/2009 of the Department of Higher Education. ସେଟା କୋଉଠି ଲେଖା ହେଇଛି? ନା ଆମ କାଉଣ୍ଟରରେ ତ କହିଛନ୍ତି।
ଆମେ କାଉଣ୍ଟରରେ କହିଛୁ ଆନେସର A/3 ବି ଦେଇଛୁ ଡକୁମେଣ୍ଟ।
A/3 this is a resolution by the state government, by the higher education
By
department.
the higher education
It does
department.
not contain any stepping up of it.
No, there is no provision. That is what we have stated.
But in view of the statute or provision,
First para ही sir.
Huh?
ସେଇଥିରେ first para ରେ ହିଁ।
कौन लिखा
That is only in continuation to the finance department notification of that 12/2008. This is in respect of this employee. So
where is it? Where is it? Please place it.
ନା ମୁଁ କହୁଛି ଏଇ ଫାଷ୍ଟ ପାରାରେ ହିଁ ଲେଖା ହେଇଛି ଯେ referring to the 24/12/2008 finance department guideline, finance department rule, my lord, of ORSP rule 2008, my lord. This is what it has been given effect to, my lord, with respect to the employees of
Whatever the finance department said, that has been come back. That doesn't mean that the rule will.
Because that is only a clarification.
So bill provides for stepping up service code.
Yes.
Rule like as a parity. DA allows a council.
हाँ माने
74 provides service code for stepping up. If any junior gets more salary, that is stepping up is entitled for. If that is meant for this public servant, government servant. So rule 9 of the 1974 rules, it says parity. Pay deliberations allowance in respect of suspension allowance also. So read also.
Heard Sri S.K. Sharma, Learned Counsel for the S.N. Sharma. Sorry.
In my rejoinder, I have taken this time.
Rejoinder दरकार नहीं
The rejoinder to para 4.5, I have stated about the rule 9.
in the rejoinder file para in the rejoinder to the counter filed by the petitioner, in the rejoinder filed by the petitioner to the counter filed by the state, it is stated that rule 9 of the Odisha Education bracketed recruitment and conditions of service of teachers and members of the staff of aided educational institutions, rules 1974 provides for parity of pay, dearness allowance, etc. of employees of aided institutions with their counterparts in the government educational institutions. Heard Sri S.N. Sharma, Learned Counsel for the petitioner, and Sri S.N. Patnaik, Learned AGA for the state. Sri Sharma submits that rule 9 of the 1974 rules, bracket 1974 rules is very clear to the effect that the employees of the aided educational institutions are entitled to salary and DA at par with their counterparts in the government educational institutions. Therefore, the stand taken by the state in its counter cannot be accepted. Para. Sri Yasan Patak, the United States Counsel, would argue that by resolution dated 21/5/2000, the government and Department of Higher Education extended the benefit of revised scale of pay 2008 to the employees of the government aided colleges, non-government aided colleges. Stop. However, no provision for stepping up / anticipation of pay was provided therein. Para. This court, after hearing the parties, finds that the petitioners' grievance raised through their multiple representations has not been addressed by the concerned authority as yet. It goes without saying that it is for the authority to take a decision either way on the grievance of the petitioner, of the petitioner's stop. However, in view of the particular stand taken by the opposite party in its counter, this court has considered the matter with reference to the relevant clarification issued by the Finance Department and the provisions of the 1974 rules. So, as already stated, the Finance Department has issued the following clarification. At page 45, right? The question and answer data ko quote karo. Point of doubt or clarification? It is true that there is further in the resolution dated 21/5/2000 of the Department of Higher Education, there is no specific provision prescribed for stepping up / anticipation of pay of seniors with their juniors. But then the 1974 rules takes care of such contingency through Rule 9, which Rule 9 bracket 1, which reads as follows. Quote kar do. Judgment is occurring. Thus, there being a clear statutory provision governing the field, there is no way by which the benefit of stepping up / anticipation of pay of the petitioners can be denied. So we'll allow the writ application. We'll direct the authorities to take a decision in this regard, taking note of this. To such extent, therefore, the stand taken by the opposite parties in their counter as referred above is untenable. Stop. For the foregoing reasons, therefore, the writ application is disposed of, directing. We will grant you liberty to file a fresh representation. Granting liberty to the petitioners to file a fresh representation addressed to
opposite department, the regional director.
To the regional director to Nati. It's no longer regional director. Mr. Patnaik?
Regional director. Regional director.
Say
it is better 1 or 2.
Director would be sound better.
Opposite not 2.
To the director higher education, Odisha. Collegially, liberty is granted to the petitioners to submit.
To the address.
Cornwall clear ago for
granting liberty to the petitioners.
Granting liberty to the petitioners to submit fresh representations addressed to The director higher education bracket opposite party number 2. Ventilating their grievance. Stop. Within 2 weeks. Within 2 weeks, stop. If such representations are filed within the period stipulated, comma, the director shall consider the same in light of the clarification issued by the finance department, taking particular note of rule 9 bracket 1 of the 1974 rules. A lawful decision in this regard shall be passed by the opposite party number 2 by the director within a period of 4 weeks thereafter.
Item number 16.
Yes. Anything?
Without taking my concession.
I have not taken the concession.
May I submit, madam? The basis is 2008 guideline resolution of finance department. The higher education department issued that notification in respect of the non-government aided college, my lord, in 2009. So if that is a clarification of 2008, how that will not applicable to 2009?
So they have not referred to, but this aspect has not been considered by the authority.
Yes.
So for the first time,
Yes.
Yes.
Well, the petitioner was appointed as a Jogan Sayak Mala. While continuing as such, he was issued with a so-called notice by the collector under Annexure 3, upon which he submitted his reply. That has not been considered, and the BDO, in view of the letter of civil supply officer, directed to disengage me. Annexure 9 Mala. The so-called the counter they have filed. That
Who has filed you have filed the counter?
Yes. State has filed a counter. In counter, they have submitted that after hearing the matter, but no opportunity was given to me. Twofold allegations are there. One is misbehaving the teacher, and second is misappropriation. That money I have been deposited. I have also submitted in my reply that money I have been utilized in that Corona Center, my lord.
Where is your counter? Your counter is not on record, Mr. Das?
Yes, I had filed the hard copy also on the
hard copy.
Last copy.
You are appearing for whom?
I am on the opposite party of 6 minutes Sarpanch, who has recently died, my lord, and I have no instruction regarding the present Sarpanch. So,
This can what is your stand?
Our stand is that on the basis of the allegations were found to be correct.
How was it inquired upon? Inquired?
Pardon?
Was it inquired into?
Yes.
All right.
Next also the document.
Then one of the parties has died, so Asu, chuti par asu.
Sarpanch.
Sarpanch ki jina but apna party corruption and once he has appeared. Sir, you are Mr. Das?
yes, man.
Sri S.C. Das, Leonard.
RB Das, Raj. My name is RB Das, Raj Bimal Das.
Limited prayer, my lord. Let the collector take a decision after giving an opportunity of hearing. Because no.
What do you say?
That for your lordship to decide.
No, but then I'll have to consider what is the counter. What stand have you taken in the counter?
You have taken that everything was, all the allegations have been inquired into and found to be correct.
So you say that there was no inquiry?
No inquiry. Inquiry ହେଇଥିଲା ତ ଆହୁରି ଅଫିସର ବି ଆସିଥାନ୍ତେ ସେ କହିଲେ ଯେ ଫେକ୍ ଇଏ କାର୍ଡ ସବୁ ଦିଆ ହେଇଛି ମାଇଣ୍ଡ ଡ୍ୟୁଟି ନଟ୍ ଟୁ
No, we'll hear this matter. We'll hear this matter and thereafter we'll pass an order. If that order is to be passed also, the entire counter has to be gone. Sri R.B. Das, Learned Counsel appearing for the opposite party number 6, submits that his client has expired in the meantime and he has no instructions from the present incumbent, for which he requests for some time. List this matter in the July record?
3rd July.
3rd July. On which Sri Das shall take instructions from the present incumbent and applies the court accordingly.
Item number 17.
This is an application for transfer of the
Yes.
matrimonial proceeding from Koraput to Bhubaneswar. Admittedly, in this present application are the instructions.
The report of the mediator indicates that mediation between the parties was unsuccessful. Yes.
My lord. The present application are the instance of the wife. But the wife is serving at Indore and the husband is serving at Koraput. Marriage was solemnized at Bhubaneswar. And also the wife also is residing at the parents of the wife, the petitioner, is also residing at Bhubaneswar. 3 proceedings are now at Bhubaneswar. One is Section 9, restitution of conjugal right. Another is 125 proceeding, and another is diving case at Bhubaneswar. One divorce proceeding was filed at the instance of the husband at Koraput. It was set ex parte, indicating that the wife was residing at Hyderabad in service. So in that view, the case was set ex parte, and in the pendence of the case, it was restored also there, in Koraput. So now it is pending, Koraput case. Now, with the prayer that is 550 km distance from Bhubaneswar. My parents are residing at Bhubaneswar. 3 proceedings also there. They are also appearing at Bhubaneswar. So in that view of the matter,
is what you said.
My prima. This is not the distance between Bhubaneswar and Koraput. She is serving there in Indore. If she can come from Indore to Koraput, Bhubaneswar, then why not Koraput? Firstly. Secondly, my lord, the only ground that has been taken in the case is Koraput is not safe for a lady.
service place.
Present day, Koraput is not safe for a lady. Indore is safe. Bhubaneswar is safe. But Koraput is not safe. That is the only ground that he has taken.
He probably has never visited Koraput, that is why he's
my lord. Koraput, my lord, her marital home is Koraput. She was residing with me in Koraput. Bhubaneswar was never a day her home. After marriage only, he has gone to Koraput because his father is retired and thereafter they have shifted to Koraput. But she has never gone there because she was in job.
What is your profession?
I am an assistant professor in Bhavanipatna Medical College, madam. She is an officer of the ICICI Bank. Therefore, there is absolutely no reason why the case should be done. Moreover, this video facility is there.
Learned friends is appearing in all cases. At Bhubaneswar,
No, madam, I'm not appearing in Bhubaneswar. I don't go there.
No, but
And the section 9.
There are 2 things. A lady coming from Indore will find it convenient at Bhubaneswar rather than Koraput. Because
but no cause of action has taken place in Bhubaneswar. No cause of action. It is neither the marital home nor the
3 other proceedings are pending. When it's a question of transfer, they get the convenience of the lady.
file the petition anyway. I will contest it on the ground of residence. I will contest it on the ground of jurisdiction.
but wife's inconvenience is to be
One petition it has already been dismissed. The first petition was dismissed. He has withdrawn. Second petition, this is the second petition. Second petition was also dismissed.
Already file your objection.
I have already filed the objection.
Filed objection, yes. Oh, counter.
Counter I have filed.
We will hear it after vacation.
Well,
We'll full length
but
hearing.
the case is continuing there in Koraput. He is not appearing there.
No, case is
matter because
This has not been stayed, my lord.
now I'm saying previously it was stayed matter. Yes, it was not dismissed for non-prosecution. Then it was restored. So now stage 2 continue.
No, stay cannot
I will grant you liberty to move for adjournment. The court will consider that.
Yes.
That will.
Yes.
It will always stay. All right.
He has always refused all the
It is
summons
submitted,
from the court, my lord.
it is submitted by learned counsel to the parties that the matter is ready for final disposal. So, and the request for fixing a date. So, place this matter on 10th July. Yeah. In the meantime, if an application is moved for adjournment on behalf of the petitioner wife in the court below, the same shall be considered having regard to the date of hearing of this case.
Yes.
Item number 18.
Item number 18.
Item number 19.
My lord, I am appealing for the opposite
Item
party.
18. Item 18, your lordships, in the last occasion, your lordship had sent the parties for mediation.
Your video is not working, you are not visible. You are not visible.
Uh,
There may be some problem in your connection. I am passing it over. Please check and then we will see.
yes, your lordship.
Item
Yes.
19.
19.
Maybe.
Last occasion, on basis of my submission, my lord, I am for the husband
Yes.
and my lord and friend for the wife. I have filed a matrimonial suit at Rairangpur. Now she has come before lordship for transfer of that applications. So last occasion I had proposed the Kenjur will be the middle area where both can go and attend the case, because I am a junior engineer posted at Korjia. She is the deputy manager of PNB posted at Bonigarh. So on that score, my lord was pleased to direct.
200 kilometers from the Raurkela.
ଆଜ୍ଞା କେମିତି ବାଟ ତ ମଝିରେ ଏତେ କୋଉଠି ହବ ଫଣିଗଡ଼ରୁ
And marriage occurred at Koraput, my lord. And both are stayed at Raurkela. And beyond the jurisdiction, they are filed CPD.
Yes, that you can contest.
Yes, ma'am.
That you can always contest.
can raise at
It is
time of
200 kilometers from the Raurkela.
No, there are two aspects. If you want to contest that case on the ground of territorial jurisdiction, that is one part. That is one part.
Yes, ma'am.
If both cannot occur simultaneously.
that
If
is
you
not
say that the proceeding is not maintainable there, I should have been filed in Koraput. Or where they were last residing, that is Raurkela.
Yes, ma'am.
Then how can you ask for transfer now? Either you have to challenge the proceeding. It's open to you.
So the Raurkela to Kenjur is 200.
not ରାଉରକେଲା ବଣିଗଡ଼ କହୁଛି ମୁଁ ଆପଣଙ୍କୁ ବଣିଗଡ଼
He is residing at Raurkela.
ଆଜ୍ଞା ବ୍ୟାଙ୍କରେ ଚାକିରି କରୁଛି PNB ବଣିଗଡ଼ ବ୍ରାଞ୍ଚ ଇଜ ଦ ଡେପୁଟି ମ୍ୟାନେଜର
50 kilometers.
Kyozhur to Korangia is not very far.
nowadays.
Whatever, it is not very far. But Bonai is slightly far. Bonai one has to go through that Paloda and that Bonai. So what do you say? Yes, if you agree, then I can pass that order.
I will take interest.
Sri Biroja Prasanna Das, learned counsel appearing for the opposite party husband, submits that if the proceeding is transferred to a third place, to another place, such as Kyozhur, it would be convenient for both parties. Hello. Sri Dalai learned counsel for the petitioner wants to take instructions in this regard from his client. List this matter
26 June.
on 26 June.
Public.
What are you seeking transfer?
I am seeking transfer of the case from Jagatsinghpur to Bhubaneswar
Yes.
on the ground that the petitioner is residing at present at Bhubaneswar with his parents, and she is a doctor. She is having a baby also.
We'll do one thing. We'll record that he is not present today and we'll fix it on 21st.
I think 21st. This 20
Yes.
after vacation. 21st.
All right.
Let it come out of vacation.
All right. Sri Minister learned counsel for the petitioner is present. There is no appearance from the side of the opposite party. On the last occasion also, there was no appearance from his side despite sufficient notice. However, in order to grant one more opportunity to the opposite party husband to appear, list this matter on
26 June.
26 June.
Item 21. Interim order is to be.
In order to continue. Service on notice complete on opinion, notice written from opinion 3, the was refused to take delivery. One who required deceased. A difficult matter. Yes.
May pray
Wait.
for withdraw the petition.
Office note indicates that notice on opposite party number 1 and 2 is sufficient.
But in the meantime,
Both. Notice on opposite party number 3 was refused. Hence, notice on notice against said party is held to be sufficient. notice issued to opposite party number 4 and 5 has returned. Who 4 and 5 with the endorsement that they have expired. Stop. You have to substitute them or to delete them.
In the meantime, I filed this application for to transfer the case from one court to another court because of
I had asked you to find out whether the district judge can do it.
my in the meantime, PO had joined.
So you are not pressing it.
Yes, my lord. So I don't want to press the matter. I have already taken instruction from the conducting counsel from the court below.
Not from the client. Not from the client.
The client has not instructed me. Conducting counsel instructed me.
You want to withdraw? File a memo.
My lord.
Then counsel for the petition seeks permission to withdraw the application. Permitted to withdraw. Dismissed as withdrawn.
Item number 22. May I please?
Also, the petition of the wife seeking the transfer of the case from civil judge senior division Kozhara to family Kalram.
Who is appearing?
I have no objection if the proceeding is transferred from Kodala to Barampur.
All right. The petitioner wife has filed this application seeking transfer of MAT case number 2 of 2024 pending in the Court of Learned Civil Judge Senior Division Kodala to the Court of Learned Judge Family Court Barampur. Stop. Said case has been filed by the opposite party husband for divorce.
Well,
For divorce. Stop. Notice being issued. The opposite party husband has entered appearance through Sri S.K. Pradhan, learned advocate. Stop. It is Sri Pradhan submits that his client has no objection to the proceeding being transferred as desired. Stop. This court finds otherwise finds that the petitioner has filed this application for transfer on ground kahin?
Paragraph 6.
Kodala is 130 kilometers. Kodala is 130 kilometers from Barampur.
This is borderline. Patrapuri is borderline.
Kodala.
Kodala is 60 kilometers.
Like Kodala to residential house of the petition.
Oh, Shea Konso.
See the resident of
60 to 65 of Kodala Barampur.
Yete bhi hogani.
60 kilometers.
60 हाँ से.
55, 60.
आ पात्रपुर टा कौन 130 किलोमीटर?
It's a borderline of Kodala.
हाँ वो जानी चाहिए borderline जानी चाहिए किंतु 130 किलोमीटर.
Also,
80 kilometers खंडा होगा.
130 किलोमीटर का बेला.
130.
नहीं कौन निकलो? Inter alia on the ground that she is presently residing in her parental home, which is near Patrapur, which in turn is at quite a distance from Kodala. Therefore, it would be convenient if the case is transferred to Barampur. In view of the submissions as above, as also taking note of the fact that the opposite party husband has no objection to the transfer, to the proposed transfer, the prayer for transfer is allowed.
Okay.
It is directed that proceeding in so and so, pending in such and such court, be transferred to the Court of Learned Judge, Family Court, Ganjam at Barampur. Learned Judge, Family Court at Barampur shall issue notice to the parties for their appearance and thereafter proceed in accordance with law.
Item 23.
May I please, Your Honor? I was working as an Anganwadi worker since 16 years.
Yes, what is your instruction?
Is that instruction, of course, specifically though I have not got, But your lordship will kindly find from the order itself, it has been discussed. He has referred to the bank slip and all.
No, you have to obtain that instruction. Looking at that order,
Yes.
after seeing that order, this order was passed. So I can grant you time, further time. Even though on the last occasion I had said that I will not grant time. But today, everybody being in the vacation mood, I can grant you time.
But your lordship will at the same time find that this being an appeal of the first appeal of the time after the new rules has come.
Okay.
He has a scope for a second appeal also.
What do you say?
Where these things can be gone into if it was the bank document annexer 8.
Second appeal is there before the RDC.
If he agitates also these questions there, that may be thrashed.
On that observer is permitted.
All right. The petitioner has approached this court with the following prayer. The case of the petitioner is that she was appointed as Anganwadi worker of Dhobasila Anganwadi Center under Koi Gram Panchayat? Under Koi Gram Panchayat again?
Odia sahi.
Gram Panchayat Odia sahi?
That is the
No, Gram Panchayat on Dhobasila Anganwadi Center packet Odia sahi? In the district of Baleshwar. On the basis of an FIR lodged on 2/1/2023 in the Nilagiri police station against the petitioner for withdrawal of government money by forging signatures of ward members. Stop. A show cause notice was also issued, to which the petitioner replied. However, by order dated, where is that imputed order?
Annexure 9.
Annexure 9.
No, Annexure 9 is appeal. Disengagement order.
Annexure 4.
By order dated 15/5/2023, passed by the sub-collector Nilagiri, the petitioner was disengaged. She filed an appeal.
Yes.
Being Anganwadi appeal number 16 of 2023 before the collector Baleshwar. Stop. Said appeal was rejected, dismissed.
Yes.
By order dated. कितने से order dated हो? 2/2/2024. Stop. In course of hearing, it is brought to the notice of this court that the remedy of second appeal is available to the petitioner against the impugned order in view of कौन सा था दिखा clause 10D ना कहते देखिए पैराग्राफ से हम उसे सब क्लियर आंगनवाड़ी
Copy of which
in view of paragraph 10 bracket small d of the revised guidelines for selection of Anganwadi workers / mini Anganwadi workers / Anganwadi helpers of the government in Department of Women and Child Development dated 15/3/2023. Yeah. Since alternative efficacious remedy is available to the petitioner against the impugned order, this court is not inclined
to entertain this application. Stop. The writ application is disposed of, granting liberty to the petitioner to prefer second appeal before the appropriate authority within, within 2 weeks from today. Stop. If such application, if such appeal is filed along with the petition for condemnation of delay, when did you file this writ application? On 5/3, within a month.
Within now 1.
But that is to be filed within 2 months. And within 2 weeks. Such an appeal is filed along with an application seeking condonation of delay from other same shall be admitted, condoning the delay in view of the fact that the petitioner had bona fide approach to this court against the impugned order within the prescribed period. Stop. Further, the appeal so filed shall be disposed of in accordance with law after granting opportunity of hearing to all concerned within 2 months thereafter. First Sri R. Das, learned AGA, submits that the information sought for has not been received. Stop. In view of the order passed on the last occasion, the matter is taken up for hearing on the basis of available pleadings without waiting for further instructions from the State Council. Stop.
Item 24. No. My place. Not case 7. It is the order, my lord, order dated 12/4/2023. As per inadvertently, it is mentioned that release this matter 2 weeks after, my lord. Though the case has been disposed of, the trial court is not proceeding, my lord. Sir, a modification.
Considering the submissions, paragraph 4 of order dated 12/4/2023 be deleted.
Dispose of may be reflected because the trial court is not proceeding since it is so.
Even if I delete it, it will not proceed.
No, my lord, dispose of reflected. Though in the website it has been showing the dispose of.
Delete deleted be substituted by the following words. The CRLMC is disposed of accordingly.
Okay. Website dispose of the coach.
Item 25.
Basi chalak.
25 or lordship
time লাগিছে I had called for some director of prosecution.
Why the material witnesses were not taken, why they were declined.
Recall application location 3 level.
Okay.
Location level election.
It order gala apre poke.
हाँ लेकिन शिकायत भी selection. As directed, the director public prosecutions Orissa has submitted a report stating that the concerned public prosecutor did not examine charge sheet witnesses number 10 and 11 as he found them not supporting the case of prosecution while refreshing their memory. Accordingly, she declined to examine them on the date of trial. Stop. However, she has filed an application on 8/5/2024 for recall of, they said, recall to me under section 311 of CRPC, seeking to summon the witnesses so declined to be examined by her. Copy of such petition is enclosed to the report of the BDPT. Such being the report, no further order needs to be passed by this court. The matter is dropped. Yes. Chitara, consider kari.
26.
Permitted to withdraw.
Permitted to withdraw item 26.
Item 27.
Dismiss for default ହେଇଥିଲା.
Dismiss for default ଆଜ୍ଞା ଗୋଟେ 12/2 ର order, peremptory order ଗୋଟେ resti dismiss କଲେ 19/3 ରେ. ସେଟା 52A Excise Act. But inadvertently one order has been passed, my lord. Include informant as the opposite party number 2 something. For that reason, I have filed one IA for appropriate modification. But that has been dismissed due to peremptory order by this honorable court.
All right, restored. Considering the submissions, restored open. ABLAPL has been restored open. Yeah, though.
ABLAPL.
It has been restored. Now you have filed another application in that anticipatory bail application for modification.
No, IA has been pending. IA pending. IA pending ଅଛି ଆଜ୍ଞା.
ଏଥିରେ ନାହିଁ.
ଏଥିରେ ଦେଇ ନଥିବେ 389 of 2000.
ଆସିବ IA ଆସିବ.
Again, order, I have to mention a matter with the matter. Well, this is a matter, this is a TRPC where business council will withdraw his power, my lord. So this matter is posted on 28th June, my lord. It's a transfer matter, my lord. So this matter will be taken tomorrow, my lord. In consideration, both wife and husband are agreed for the divorce, my lord. And the present matter is there in Sambalpur, and the wife is at Bhadra, my lord. So this matter might be disposed of tomorrow, my lord.
Why?
Because the husband is ready, that the matter may be transferred from Sambalpur to Bhadra.
No, but this is a fresh matter.
Yes, my lord, it's a fresh matter, my lord.
So the fresh matter, so notice has to go.
No, sorry, my lord. Notice is already, the husband has already appeared, my lord. I am for the husband, my lord.
You are for the husband?
Yes, my lord.
Who's appearing for the wife?
For the any other councils, my lord.
No, the application for transfer has been filed by the wife or the husband?
By the wife.
By the wife.
Wife, my lord.
So they have to make a mention.
Yes, my lord, because I am the husband, I am ready now, my lord.
No, you may be ready, but what is the urgency? Why should I take up tomorrow?
Because on 28th it has been
28th June.
Oh yes, ma'am. So that's
28th June ଅଛି କଣ ତାକୁ vacation ପରେ ନେଲେ ହବନି ଏତେ ବ୍ୟସ୍ତ
ସେ ଟିକେ ସେ ମାନେ divorce they both are ready for divorce ma'am.
ନା ବା ସେମିତି ଆଉ କଣ ତାଙ୍କ ପାଇଁ ଆଉ
in consideration. No, the day after tomorrow.
No. Day after tomorrow is very heavy now. You are had you been the petitioner, I could have considered. But now you are the opposite party. You are interested to relate
Yes, ma'am, because we don't have any objections, ma'am.
No, that's all right.
Yes, ma'am.
Then you ask the petitioner to come. I will see. Let the petitioner. Since this is a matter which you say that both of you are agreeable,
then I will call, ma'am. I will call.
We'll see.
Hello.
Return back to me. So file.
All right. ଲେଖନ୍ତୁ item କେତେ?
Item number 23.
23. Original କଣ file କରିଛନ୍ତି?
Input order. Annexure 479.
The original copies of annexures 4, 7 and 9 be returned to learned counsel for the petitioner being substituted by you.
Oblate.
Supplementary list item number 4.
Supplementary list. Item 4. Yes, what is this matter?
Uh, Ma'am, I have taken instruction, Your Lordship. The opposite party is presently resided at Consort Devgarh and
Is?
Consort Devgarh, and he is working as a Ayush doctor.
Irish doctor.
Yes.
And you are working as?
Junior revenue assistant.
So you are a government officer. He is also a government officer. Will it not be difficult? He is a doctor.
Sir, the distance from Devgarh to Sambalpur is only 78 kilometers. But from the Consort Devgarh to Balangir is 201 kilometers. So it is convenient to both of the parties.
How is it convenient? How? And he is a doctor.
Yes.
So it will be rather difficult for him. Where do you want it to be? Where do you want it to be transferred? To Sambalpur.
Sambalpur.
So it will be difficult for him to come to Sambalpur,
Sir,
leaving his patients.
Sir, see, the petitioner having a 2.5-year-old baby.
So how is it relevant? As compared to the person, your husband is he's a doctor. He is attending to so many persons.
Yes.
So once he leaves, one day will be lost. So many patients will go without care.
Balangir is far away from Sambalpur, Your Lordship.
He may be far away, but for that person to come to Sambalpur again, that will be difficult.
No, sir. The Sambalpur is only 78 kilometers from his working place.
Where is his working place?
The working place of the opposite party is Consort Devgarh.
No.
But Balangir is 201 kilometers
Maybe.
from his workplace.
Where have you said that? Where have you said that in your application?
About the para 6, Your Lordship, in the petition.
These are the merits of the case. All right, issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow. List this matter on
3rd July.
3rd July.
I is there for.
In the meantime, if any application is moved for adjournment in the court below by the petitioner, the same shall be considered, having due regard to the date fixed for hearing of this case. Yes.
So item number 18.
Item 18, Your Lordships, in the last occasion, Your Lordship had sent the parties for mediation as per the instruction received by us. The mediation has been failed. Therefore,
The report of the mediator indicates that the mediation between the petitioner and the opposite party has failed. So you are the petitioner. Who is the petitioner?
Yes.
You are the petitioner. Yes. You are the wife.
Yes, Your Lordship.
You want transfer of the proceeding from which place to which place?
From Your Lordship's Berhampur to Malkangiri.
Berhampur to Malkangiri. On what ground?
That Your Lordships, the petitioner has a threat that if she, first of all, she can't travel to Berhampur as it is very far. And that's why she is seeking this transfer petition.
Is she residing?
She is residing in Malkangiri.
Malkangiri. Achha. Yes, Mr. Das.
Para 3, Your Lordship, kindly see one proceeding, another proceeding is pending here at Berhampur, and where she is contesting. So one case she is contesting here, my lord, another case she wants for transfer, my lord.
Oh, she may seek transfer of that case also. How do you know?
She has not filed it.
ବ୍ରହ୍ମପୁର ମାଲକାନଗିରି ବହୁତ ଦୂର
Till date, he has not filed.
ଲେଡି ବ୍ରହ୍ମପୁର ମାଲକାନଗିରି ଅସୁବିଧା ହବ you can appear through virtual mode if you want. I'll grant you that liberty.
My lord.
The petitioner wife has filed this application seeking transfer of CP number 51 of 2023 pending in the court of Learned Judge Family Court Berhampur to the there's a family judge at Malkangiri.
Pardon, your lordship.
Is there a family judge at Malkangiri?
Yes.
But you have said to the competent court in the district of Malkangiri. So the court will now, this High Court will now find out who is the competent court. Amend your application. Prayer abhisya to the competent court in the district of Malkangiri. Competent court I am खोजी बता ना. Registry को कोई बात की कोई बात जे खोजो कोर्ट को competent court अच्छी. अपन जहाँ prayer करते थे. From which court to which court you would like? That you must be clear. Your petition supported by affidavit is not clear.
If your lordships grant me some time, I'll just clarify.
No, there's no question of clarification. It has to be amended. Application for amendment. I'm calling this on Friday. You amend it in the meantime.
Yes, your lordship.
As requested by learned counsel for the petitioner, leave this matter on 17th. These things, these are small things, but these are very important.
I apologize.
No, you don't have to apologize. Be more alert before filing an application. You want a proceeding? Competent court. The हजूर जाए खोजो कोटा competent court ही तो ये कोटा पचे रहेंगे अपना competent court ना आएगा मुंडे से पढ़ देखो से चक्कर देखो से चक्कों के जाए पचे रिश्ते को ना आएगा सिटी देखो सेम हुए कि कम you must come with a definite case. ये कोर्ट को मुर्जी बात रखा. Yes. Day after tomorrow, so do whatever is necessary.
Yes, sir.
चल.
Quick list item number 1.
Item 1 कहीं? Paso.
Item number.
Okay, paso.
Okay, sir.
Yes.
Your Lordship, we had been directed to file a surrender certificate, Your Lordship. We have instruction that the present petitioners have surrendered, Your Lordship. However, since there is nobody to look after their case, they have been unable to provide us with a certified copy of the surrender certificate.
Well, I'll call it after vacation. You file the surrender certificate in the meantime.
Yes.
Ms. Bini Mr. Learned Counsel for the petitioner submits on instructions that the petitioners have surrendered to custody after expiry of the period of interim bail. But the surrender certificate has not been obtained. She requests for an adjournment on such ground. Place this matter on.
In the week commencing 1st July.
In the week commencing 1st July.
Yes.
Surrender certificate be filed in the meantime, positively.
Much obliged.
Paso item number 10.
Petitioner who is a lady, my lord, custody since 14/8/2021. Lordship kindly.
Yeah, I had asked for a report from the.
Yes, madam.
The court below has submitted a report that the trial of the case is progressing and has not been stalled for want of chemical examination report.
No, your lordship, today is the trial date, my lord. 13, 14, 15. 3 days since chemical report has not produced, no witness has summoned, nobody has appeared, my lord. That is my instruction.
Court लिखिले on 24/2023. Additional PP filed a petition for production of material objects and submission of CE report. Accordingly, direction has been given to the judge in charge Malkhana come JMFC Gora. And the ISC concerned to produce the material objects, and letter has been issued to SFSL Bhubaneswar for submission of CE. Thereafter, the evidence of 8 witnesses, PW 7 to 14, has been recorded. I beg to state that for each and every adjournment, summons have been issued to the witnesses to procure the attendance to record their evidence, and the trial of the case has not been stalled. So he is a senior judicial officer. He is writing when he is writing. Is he writing false?
They have taken instruction, my lord. 13, 14, your lordship. Thereafter.
So let us consider your bail application. Yes. What do you say? Let's consider your bail application. I get into that. ଜୁଡିସିଆଲ ଅଫିସର ମାନଙ୍କ ଉପରେ ଭାର ରାଗ ନାଇଁ
ନାଇଁ ନାଇଁ ନାଇଁ ରାଗ
ନାଇଁ ତ?
କାଇଁ ମୁଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଯାହା ନେଲି କହିଲି
ସିଏ ଯାହାଠୁ ଇନଷ୍ଟ୍ରକ୍ସନ ତାଙ୍କର ବୋଧେ ବହୁତ ରାଗ ଥିବ
ନାଇଁ, ଆଜ୍ଞା ରାଗ ରଖିଲେ ଚଳି ହବ
ସେଇ ତ ସେଇଟାକୁ ଆଗ ବୁଝିଦବାକୁ ପଡିବ ନା ହଁ କଣ ହେଇଛି ଏଥିରେ କହିଲେ
Yes,
ଯେ
so
lady
far as the lady
lady
my lord, omnibus allegation, there is no specific.
ପୁରା omnibus ହେଇଥିବ ଦେଖିବେ
Yes, your lordship kindly see the eyewitness speed of.
ଟିକେ ଆଜ୍ଞା ଟିକେ ସେଟା ଟିକେ ପଢିଦେଲେ ସେଟା ବୁଝିବା ଦୀର୍ଘ ପ୍ରାୟ 8 ଘଣ୍ଟା ସମୟରେ ମୋର ସ୍ୱାମୀ ମୁଁ ଓ ମୋର ପିଲାମାନେ ଆମ ଘରେ ବସି ଟିଭି ଦେଖୁଥିଲୁ ଏହି ସମୟରେ ଆମ ଗ୍ରାମର ସୂର୍ୟା ପ୍ରଧାନ ଖଲି ପ୍ରଧାନ ବିକ୍ରମ ନରେନ୍ଦ୍ର ସିଂ
ସୁଜାତା ପରିଡ଼ା
ଓ ବିକ୍ରମ ନରେନ୍ଦ୍ର ସିଂର ସଂଗାତ ଆବୁଆ ନିଜ ଗ୍ରାମର ଦଣ୍ଡପାଣି ନାତି ଗଙ୍ଗାଧର ପରିଡ଼ା ଏଇଟା
ପରିଡ଼ା granted bail by your lordship.
ଦୁଲି ପ୍ରଧାନ ଦୁଲି ପ୍ରଧାନ
Yes, my lord.
ଦୁଲି ପ୍ରଧାନ ଶଙ୍କର ପରିଡ଼ା ଇତ୍ୟାଦି ଇତ୍ୟାଦି
ପ୍ରାୟ କେତେ ଲୋକ 20ରୁ
କେତେ
ଅଧିକ
ଲୋକ
ହେବ ଆମ ଘର ଦୁଆରକୁ ଆସି ମୋ ସ୍ୱାମୀଙ୍କ ନାମ ଧରି କାନୁ ପରିଡ଼ା କୁଆଡେ ଗଲା କହି ବସି ଟାଣି ଆଣି କହିବାରେ ଶୁଣି ମୋ ସ୍ୱାମୀ ନିଜର ଜୀବନ ରକ୍ଷା ପାଇଁ ଆମ ବାରିପଟ ଦେଇ ଦୌଡ଼ି ପଳାଇ ଗଲେ ମୁଦଲା ମୋ ସ୍ୱାମୀକୁ ଦେଖି ସୋ କାନୁ ଘରୁ ପଳାଇ ଗଲା ମୋ ଘରେ ପଶିଯାଇ ମୋର ସ୍ୱାମୀଙ୍କ ପଛରେ ଦୌଡ଼ିଲେ ହାତରେ ଖଣ୍ଡା ବୁଜାଲି ବନ୍ଧୁକ ମାରଣାସ୍ତ୍ର ଧରି ଥିଲେ ମୋ ସ୍ୱାମୀକୁ ହାଣି ମାରିଦେବି ଭାବି ମୁଁ ମୋ ପୁଅ ଝିଅ ସେମାନଙ୍କ ପଛରେ ଯେ ଦୌଡ଼ି ଯାଇ ଦେଖିଲୁ ଯେ ମୁଦଲା ମାନେ ଆମ ପାଖ କେନାଲ ପାଖରେ ମୋ ସ୍ୱାମୀକୁ ହାଣୁଛନ୍ତି ମାଡ଼ ମାରୁଛନ୍ତି ମୁଦଲା ମାନେ ଧମକ ଦେଇ କହୁଥିଲେ ତା ବଂଶର ସମସ୍ତଙ୍କୁ ହାଣି ଜୀବନରେ ମାରି ଶେଷ କରିଦେବା ଆମ ପିଲାମାନଙ୍କୁ ମତେ ଦେଖି ମୁଦଲା ମାନେ ସେଠାରୁ ଦୌଡ଼ି ଯାଇ ଗଲେ ମୁଁ ସ୍ୱାମୀଙ୍କ ପାଖରେ ପହଞ୍ଚି ଦେଖିଲି ଯେ ମୋ ସ୍ୱାମୀ ମୃତ୍ୟୁବରଣ କରିଛନ୍ତି ମୁଦଲା ମାନେ ମୋ ସ୍ୱାମୀକୁ ବନ୍ଧୁକରେ ଲାଛି ଖଣ୍ଡାରେ ହାଣି
only that matter the daughter Kavita 161 ଟା
ବବିତା ପରିଡ଼ା statement your lordship can
PW1 minor kindly PW1 who's the
he is the eyewitness he is the lost this affair your lordship kindly peruse the statement
କିଏ ଇଏ
ସେଇ ବବିତା ପରିଡ଼ା
ବବିତା
ଆଜ୍ଞା ବବିତା ପରିଡ଼ା ସେ
ସେ ତ କବିତା
ନାଇଁ ବବିତା ଗଙ୍ଗାଧର your lordship granted bail in
ମୁଁ ତ ପଢେ ମୋବାଇଲ ଦେଖୁ ପ୍ରିୟା ପ୍ରଧାନ ଜିତୁ ପରିଡ଼ା ଗଙ୍ଗାଧର ପରିଡ଼ା ବନ୍ଧୁକ ଧରିକି ମୋଟରସାଇକେଲ ଆମ ଘର ପାଖରେ ଯିବା ଆସିବା କରୁଥିଲେ ଆଚ୍ଛା ହଉ no specific overt act PW1 ପ୍ରୀତିମୟୀ ପରିଡ଼ା who is she this is
daughter of the deceased.
Bobita Frieda stated against all.
अच्छा PM report
PM report चारटा injury ଅଛି ଚାରଟା ହେଇଗଲା that is there
ଦିଅନ୍ତୁ PM report ଦିଅନ୍ତୁ
ସେଇଥିରେ ଅଛି ଲର୍ଡସିପ ପାସ
ଏଇଥିରେ ଅଛି
PW ଚାରିଟା injury laceration your lordship kindly see PW12
PW2
12
yes laceration of size at the overlateral canthus of right eye below left knee above left knee left knee joint ମାନେ ଗୋଡକୁ ବେସିକାଲି ହାଣିଛନ୍ତି where is the bail order of the person who has been granted bail
PW1 में kindly see that.
देख सर पढ़ सर
And the other eyewitness is informant and his
just खाली name करछि but no specific overt act Surya Pradhan and you near Gangadhara Purida.
That
Gangadhara Purida, see the 161 କହିଛି ଯେ ସେମାନେ ସୂର୍ୟା ପ୍ରଧାନ ଜିତୁ ପରିଡ଼ା ଗଙ୍ଗାଧର ପରିଡ଼ା ବନ୍ଧୁକ ଧରିକି ମୋଟରସାଇକେଲ ଆମ
ପଛରେ କହିଲେ କିନ୍ତୁ ସମସ୍ତେ ଗଲେ ଦୌଡ଼ିକି ବୋଲି କହୁଛନ୍ତି। FIR 161 ରେ ସମସ୍ତେ କହୁଛନ୍ତି।
No specific overt act. It's just part of that.
That the minor has stated specific name of the Vikram and present petition.
No, she's ଏଇଟା କହିଛି ପା ମୁଁ ପଢିଲି ଏଠି। I know the accused persons in the doc. Their names are Vikram Narendra Singh and Duli Pradhan. I know the other accused persons. ଯୋଉମାନେ present ଥିବେ, ଯୋଉମାନେ କୋର୍ଟରେ ଡକ୍ ରେ ଥିବେ ସେମାନଙ୍କୁ ଦେଖି କହିଲେ ଯେ ଏମାନଙ୍କୁ ଜାଣିଛି ଅନ୍ୟମାନଙ୍କ ନାଁ ବି କହିଲା ନା। ଅନ୍ୟମାନେ ଯୋଉମାନେ ପ୍ରେଜେଣ୍ଟ ନଥିବେ ସେ ଅନ୍ୟମାନଙ୍କ ନାଁ ତାକୁ ପଚାରା ହେଇଥିବ ସେ କହିଦିବ। The petitioner is in custody since
14/8/21.
14/8/2021 in connection with such and such case. It is alleged that the prosecution case is that the husband of the informant was brutally assaulted by several persons armed with deadly weapons owing to previous enmity. Stop. They allegedly chased him when he tried to flee from their clutches and ultimately hacked him to death. Stop. The FIR contains the names of several persons and 20 others without specifying as to who exactly assaulted the deceased. The statement of the informant recorded under section 161 of CRPC also refers to several persons, including the petitioner, in general terms. One of the eyewitnesses, being the daughter of the deceased, has been examined as PW1. Copy of her deposition has been produced by learned counsel for the petitioner in court. Reading of the deposition reveals that she has also generally referred to the names of the assailants and 20 others of having assaulted her father. Stop. The postmortem report refers to only 4 injuries, 4 lacerated injuries, 3 of which are on the left leg, while 1 is on the right eye. It is therefore rather far-fetched to impute any specific complicity of the present petitioner in the absence of any evidence of any specific overt act being committed by her. Stop. Only because she was allegedly a part of the large group of persons who assaulted the deceased cannot ipso facto lead to the conclusion that she had also participated in the crime.
Yes, I am appealing to the informant. There is direct eyewitnesses at there, my lord. Though in front of wife and children, the petitioner along with some others assaulted the informant, and on the spot the victim has died. And till death, the wife and the eyewitness, another eyewitness, examination was not held in the court. This is my submission.
Moreover, the petitioner, being a lady, has been in custody for more than 2.5 years. Hello. That's purport lekhantu. First lekhantu. Heard Sri Jyotirmay Sahu, learned counsel for the petitioner, and Sri A.S. Paul. You are Mr. Paul.
Yes,
isn't it? Paul, he writes, it's Paul, isn't it?
Yes.
Dr. Paul, I believe. Isn't it? But you are not writing doctor, doctor, No, you can write Dr. Paul. Really. And Mr. A.S. Paul, counsel appearing for the informant. Also heard Sri S.K. Mishra, additional standing counsel for the state. Sri Sahu submits that the allegations against the petitioner are in general terms. And nothing specific has come out in the evidence against her. Then State Council has opposed the prayer for bail by submitting that the eyewitnesses have named the petitioner as being part of the group that assaulted the deceased. Sri Paul, Learned Counsel for the petitioner, for the informant, also opposes the prayer for bail by submitting that the daughter and the wife of the deceased are eyewitnesses to the occurrence, and they have also stated so in clear terms. Taking into consideration all the other facts, as also the period of detention in custody, I am inclined to allow the prayer for bail. Each day appearance without representation. Yeah.
And with the condition that he shall not come in contact with the prosecution.
Lady each day appearance in the court without representation. Without representation in court. Without seeking representation. Yes.
So item number 11.
So that matter, 8 years, 7 months.
Yes. Yes.
Also filed an application for interim bail.
Filed.
Yes.
And I have I have filed a reply to lordships.
Filed a reply?
Yes.
Where is that reply? Has it been filed in the court?
Yes. It has been filed in the.
If you have another copy, hand it over. Yes, what have you stated in this? Yes, what is your...
Two grounds they have taken in IA. They have not taken the ground of delay in the trial because the report came, and in report it was written that the delay is not attributable to virtually anybody. Therefore, your lordships, in paragraph 15, your lordships, we have given a reply to the grounds which they have taken for interim application.
What is the ground? What is your reply?
Should I read your lordships? Paragraph 15.
No. What is basically what? Just tell the gist. You don't have to read it. You just tell what is the gist.
There's two grounds they have taken. One is for the son's treatment, and second is for the son's education. So treatment is really not necessary because I have given the reasonings, your lordships, why. And son has almost completed his education and 1 year is only left. But all the co-accused, your lordships, all the principal accused in this case are still in jail. Gautam Kundu, Sibomai Datta, then Goswami, and all the principal accused. 9,000 crores, your lordships, is still to be repaid. And the co-accused had also filed, your lordships, for interim bail. The learned judge recused due to the reasoning I would not like to tell in this open court, your lordships. And your lordships, further investigation which is going on, 100 crores have further been added, and 2 more companies have come up, including the role of this petitioner, your lordships.
No, that's all right. But the question is, his bail application was also rejected by this court earlier. Regular bail application. Now the question is, he is in custody for nearly 8 years or 8.5 years. 8 years, more than 8.5 years. Now the trial, there is no possibility of the trial being concluded in the near future. So for how long can we keep him in custody? Because there is a direct violation of Article 21, because he continues to be an under trial prisoner, because he is not held guilty, isn't it?
But last date of hearing, I also, your lordships, made a submission that, your lordships, this non-start of the trial, your lordships, for that, your lordships, the co-accused Gautam Kundu His bail application was rejected in Kolkata High Court, your lordships, only 1 year
No,
back.
that's all. That's all. That's all. That's all. I'm not saying that. But this court will also consider that this aspect needs to be considered, because for how long can we keep a person in custody when particularly he's an under trial prisoner?
Lordship,
Whatever you say has not been proved. It is all in the realm of allegations, speculations, imagination. You never know. There are documents. That is why he's in custody. But then for how long? That is the question. We'll take it up after vacation. We'll pass a full length judgment. Whatever. Either way.
Yes, sir.
Either I allow your application or reject
I'll
it.
also give your lordships judgments of the apex court, which says that this is a clear violation of Article 21. And my lords, pre-trial incarceration is never the motive of this honorable court, my lords.
After vacation, your lordships, I would like to argue on Article 21 aspect also. How the Supreme Court has passed contrary judgments also, how Article 21 is not absolute.
No, I will not go by the judgments. I want to be satisfied myself.
Yes, your lordship. Then
I'm equally, I'm not just, you see, we will not just go by the Supreme Court judgments. With great respect, the court in each case has to see the application of Article 21. How it will apply. Yes, true, as you said that that Gautam Kundu's application may have been rejected by the High Court. There can be no precedence in bail applications. It has to be considered on on case to case basis. So
how right of speedy trial has to be balanced with the right of fair trial.
Certainly.
Lordship, I put it after.
I will because I need to pass a judgment here.
Yes, my lord. And speedy trial doesn't mean that you go on taking forever and the person remains languishing in bars.
Your lordship,
it is for them. Everyone is behind the bars. They could have started the trial. They will investigate for 40 years, my lord. This man will remain in bars for 40 years.
No, there has to be a line has to be drawn somewhere.
You have two small submissions. I will argue on the other date, your lordships. Number one, if your lordship the trial state, what steps have been taken by the accused? Have they moved any application or any writ before the High Court to any application before the court?
No. This argument will not stand at all. This argument, no, Mr. Nayak. This argument is not acceptable at all. It is not for the accused. It is your case. It is the case of the state.
We are not responsible for the delay.
So he can only whatever he could do, he has done it. He has asked for his release, which is the most sacred right of a person. He says, release me. If you can't try me, then release me. That is what he is saying. Anyway.
For arguments after
All right. Heard arguments in part. List this matter on.
We commenting 8th July.
July, sir, टिके देरी रहूं किंबा जून रे
कर दो
टिके जून रे
24th June. It will come in the week commencing 24th June.
You say first week of July. I'm going up.
The first week of July, senior counsel is not absent, will not be present. Yes.
Oblige.
So 15 May. The petition custody since 21/8/21. Alleged 21C of NDPS Act. My lord, out of 19 charge sheeted witness, only one witness were examined.
One person has been released on bail.
But he is coming on the
No.
because brown sugar was seized from the present petition.
What is the name of the accused?
Ranju Jyoti.
He has already granted interim bail.
Man.
Not once or twice. Sati, I have one.
After vacation.
No. The petitioner is in custody since 21/8/2021. In connection with such and such case. The present application for bail has been filed on the ground that on the ground of delay in conclusion of trial. Taking note of the delay In conclusion of trial, this court has already granted interim bail to the petitioner on 2 occasions, as per order passed in BL appeal number 413 of 2022 and 11913 of 2022. Stop. Since trial has already commenced with 1 witness being examined, I am not inclined to allow the prayer for bail. The bail application is therefore rejected. Yes.
So item number 19.
Right, please. Operational 20B2C, 25, 27A, 29 of NTP Act, my lord. Custody since 111, 2023, my lord. And the present petitioner is escorting my lord the vehicle, my lord.
625 ganja.
Yesterday or day before.
This matter was yesterday. This matter was there. He has supplied that FIR copy. And my lord, that on the similar footing, another person, Jacob Killa. Your lordship was directed to call for the city, and it was posted to 13.5. Perhaps it was not listed. These both matters be taken up.
So
city was called for. Yes.
So city is not available here.
No, mate.
Appropriate case that we obtained. List this matter along with BLAPL number
1506 of 24.
1506 of 2024. In on
The 20th May.
In the week commencing in
24th June.
In the week commencing 24th June.
He is escorting me.
Yes.
Present petitioner is escorting me.
Case date আসলে তো দেখিও case date দেখিও যদি সে আইতো তো হবো
এফআইআর মানে পুরা লেখা আছে কি সে বাইক রে থিলে ছে
case date আসু এনডিপিএস কেস রে 600 কেতে কেজি আপন কোন কହୁଛନ୍ତି এফআইআর দেখি বেলতে দেই দেবি
So item 21.
Please, my lord. My lord, here the present petitioner is behind the bar since 24/7/2021. My lord, allegation is 20B2C NDPS Act, and he is a daily wager. Unfortunately, he could not also avoid the order of his master, who is also the owner of that vehicle and also transporting the ganja. That is, that is one Karno, Parmeshwar Karno. My lord, the Parmeshwar Karno, he is also the owner of that vehicle. He also admitted that he is also transporting that ganja. Unfortunately, only he could not avoid the order of that his master. He only given a company. He is a daily wager, and he was accompanied with him, as having no nexus with this so far the allegation of the transporting ganja is concerned. Neither he is a owner, nor he has any transporting with nexus with him. Only the allegation is that Parmeshwar Karno. And he has also confessed and that he has transporting that the contraband ganja, and he is also the owner of that vehicle. And he is behind bar since 24/7/2021.
What is the status of trial?
Trial has not yet been started.
The court below is directed to submit a report regarding status of the trial. Further case diary be obtained. List this matter in the week commencing 24th June. This order be communicated to the court below forthwith. Yes.
So item number 28.
Lordship, kindly taken up after vacation.
Week commencing 24th June.
So item number 34. No, please, Lord. I filed an interim application 540 of 2024 for interim release for 3 months, madam. He is in custody since 23/8/2021. Out of 16 witnesses, 3 has been examined, and the quantity is 450 kilogram, from which 6 persons from the spot they were apprehended. All total on investigation, 5 more were found. Total 11 number of accused persons are there, and he has not been released in interim, not even a single time. This is the first application for interim I'm praying. For nearly about 2 years, 9 months, man.
Your earlier application has been dismissed for non-prosecution.
It was dismissed for non-prosecution, but previously the
first application of the co-accused was withdrawn in this court. So that Pradhan Jani.
No, doesn't matter. I'm not on that. You should have sought for restoration of that
He
application.
was some different counselor. I don't have any problem. Se CRLM file करते से CRLM रे तांगर dismiss हो जाइए. से भी आओ नहीं. Dismiss or default है कि CRLM में file.
So how can another application be considered?
मतलब
How can a fresh application be considered?
Because co-accused first जेतल file ହେଇଥିଲା सेटा हजूर को कोर्ट ରୁ withdraw ହେଇଥିଲା. तो प्रधान जानी अनुसार से judgment.
No, सेटा मु कहूनी. Your application Kishanto Naik application was dismissed for non-prosecution.
आया. तापर ओटे CRLM में से counsel file कर.
That was also dismissed.
से भी dismiss है. अब तापर और recourse I don't have.
So you will have to file another CRLM rather. No, CRLM.
CRLM में से withdrawn कर दीजिए.
So how can you maintain another application? This application will not be maintainable. You just simply file a CRLM. In that very application, it will be restored and order will be passed. Whatever order you, interim bail. You file a CRLM. Otherwise, this order will stare at you. The technical difficulty.
We don't have any problem with that, my lord. But provided is that, my lord, at this juncture, to be honest with you, my lord, at this juncture, I will be misunderstood by my client only. This is the fact, my lord. This is the factual background of the case that I will be misunderstood by my client itself. I don't have any recourse to go after that, my lord. Whether to file again as CRLM and to restore that application, again to come with that fresh bail application by restoring it.
No, fresh bail application will be automatically withdrawn or you will withdraw it. In that application which is restored, the prayer can be considered.
Time like मना करने अपन जोड़ा कोचन ठीक but problem हो ची.
Court is always right.
मैं मना करनी but
court is always right.
problem हो जाएगा मुंह संदेह को wrong है जो जल्दी आशी और पास ना वाला.
नहीं हवने technical mistake टा करियो. You file a CRLM. I am keeping it pending. I am just not passing any order. You file a CRLM, make a mention. I'll take it up before vacation. It will be restored and the bail application will be taken up on the same day. You file a CRLM.
21.
No, this one. This application. Yes. Raise this matter next week as prayed for. In the meantime, you do whatever you want to. So that this present application will withdraw and the other application will take the order.
Obviously.
So item number 46. Last week, yesterday, lordship filed a modification already filed, my lord. So all the co-accused person already released and well, except for petition number 4, my lord. So lordship direct to first hour and second hour.
नहीं कुछ मैं बुझ पारे नहीं इधर
687 बीजी से तो इक्वल
ये कौन से ये सेटा
काली थी
हां ये फाइल को से you want a modification
my lord not press fresh bail application not press it modification
नहीं एटा लिस्ट अछि की
हां लिस्ट अछि मु आउट फाइल करथिलो
नहीं एटा लिस्ट अछि आ तले
the connected के आसीलो एटा रेफरेंस अछि
मेरे कल नहीं है सर bring this matter tomorrow supplementary list नहीं है सर এটা নট ফেস করব এটা কালি কিনে আসুন
নট ফেস
এটা রকম তো কালি ফাইল করবে
পারমিটেড উইথড্র মানে
হ্যাঁ পারমিটেড টু উইথড্র তাহলে সেটা ফেলে দিও
স্যার
সেটা কালি কে স্যার ম্যাটার কোর্ট ফাইল করে দিছি এ ফাইলে মেমো নাও মেনশন মেমো
মাইল
মেমোটা দিন সঙ্গে সঙ্গে স্যারটা কালি কিনে আসবে সাপ্লিমেন্টারি নিয়ে আসবে
আসলে
এটা মিলডি উইথড্র করো তো
এটা উইথড্র হ্যাঁ 48
May I please? The petitioner is lady lordship offense under section 306 34 IPC FIR register. In the meantime, preliminary charges submitted under section 306 34 323 452 294 506 IPC lordship. The allegation that lordship
allegation is against one Sima
Behra.
Three person named in the FIR lordship.
सीमा बेहरा एवं हरि बेहरा आम घर मो पुआ अजय मुदुली को टाणी नहीं रास्ता ऊपर को टाणी नहीं लुहा रड और ठेंगा साहाय्य मारिया लगे फल मो पुअर मुंड फाटिगला मो स्त्री बदनी इत्यादि छड़े जो आमको बाड़ेला सीमा बेहरा एक रड साहाय्य मो हाथ को बाड़ी फटेदेला ये अपमान को सह्य न करि पारी विष पी देला तेणु आम मो पुओ को तुरंत 8 मेडिकल को नहीं गला
In fact, Your Lordship, the assault allegations made in the FIR, it is totally false. And the Lordship kindly have a glance on the 161 statement of the informant. Is at page 23, Your Lordship. 23 I have annexed, Your Lordship. The fact remains, Your Lordship, the deceased and his wife, they quarrel. Yes. ମୋ ନାମ ସୁରେନ୍ଦ୍ର ମୁଦୁଲି ମୋର ଦୁଇଟି ପୁଅ
ସୁରେନ୍ଦ୍ର ମୁଦୁଲି ଇଜ ଦି ଇନଫର୍ମାଣ୍ଟ
ୟେସ୍ ଲର୍ସିପ ହେଲା ସେମାନଙ୍କ ମଧ୍ୟରୁ ଦୁଇ ପୁଅ ଯାହାର ନାମ ବିଜୟ ଲର୍ସିପ ଗତ 22/12/23 ଦିନ ସକାଳେ ମୋର ପୁଅ ଅଜୟ ସହିତ ବୋହୂର ପାଟିତୁଣ୍ଡ ହେଲା ତାପରେ ମୋର ବୋହୂ ତାର ପୁଅ ମଝିଆ ଝିଅକୁ ନେଇ କୁଆଡେ ଚାଲିଗଲା ଆମେ ଖବର ପାଇଲୁ ଯେ ସେ ଆମ ଗାଁ ପାଖରେ ହରିବେରା ଘରେ ଅଛି one of the accused. ସେ ତା ପରଦିନ 23/12/23 ଦିନ ତାର ବାପ ଘରକୁ ପ୍ରଶାନ୍ତ ବେହେରାର ଅଟୋରେ ଯାଇଛି ଦ ହଜବାଣ୍ଡ ଅଫ ଦ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ସେହି 23/12/23 ସନ୍ଧ୍ୟା 7ଟା ହେବ ଆମ ଘରକୁ ସାବିତ୍ରୀପୁର ପ୍ରଶାନ୍ତ ବେହେରା ତାର ସ୍ତ୍ରୀ ସୀମା ବେହେରା ତା ସହିତ ହରି ବେହେରା ଆସିଲେ ଓ ଆମ ଘର ଭିତରେ ପଶିଲେ ଓ ମୋ ପୁଅକୁ ଖୋଜିଲେ ମୁଁ କହିଲି କଣ ହୋଇଛି ସେ କଣ କରିଛି ସେମାନେ ମତେ ଅବଧର ମୋ ପୁଅ କଣ ଲେଖିକି ତାପରେ ମୋର ପୁଅକୁ ତାର ରୁମ ରୁ ଟାଣି ଆଣି 3 ଜଣ ଯାକ ବାହାରକୁ ନେଇଗଲ ଦାଣ୍ଡରେ ଲୁହା ରଡ ଠେଙ୍ଗାରେ ମାରିବାକୁ ଲାଗିଲେ ତାପରେ ତାର ମୁଣ୍ଡ ଫାଟିଗଲା ଆମେ ଯାଇ ଛଳିଲା ବେଳେ ମୋର ଦେହରେ ମତେ ବାଳ ବାଜିଲା ଆଉ ସେମାନେ ବି ଆମକୁ ପିଟିଲେ ଆମକୁ ବାଡେଇବାର ଦେଖି ଅପମାନିତ ହୋଇ ମୋର ପୁଅ ହଠାତ୍ ଘର ଭିତରକୁ ପଳାଇଗଲା ଆଉ ଘରେ ଥିବା ପୋକମରା ଔଷଧ ଡବା ଖୋଲି ପିଇଦେଲା ସବସିକ୍ୱେଣ୍ଟଲି ମେଡିକାଲ ଗଲା ମେଡିକାଲ ଟ୍ରିଟମେଣ୍ଟ Yes, so but the assault is concerned. Your Lordship kindly have a glance on the PM report. Page 32, last page of the brief. PM report रे external injury किछि नहीं. सी कहते तांको रड रे बाडेले एवं मुंड फाटीगला. किंतु PM report Your Lordship external injury top of the page 33 no external injury there.
Yes, Mr. Mishra, this is very significant. Yes. The specific case era मुंड रे मारला फटेतला. Right. Rod. There is no injury. There is no injury. से जो विष पी देगी जो कारण पी सब
तारा
the petitioner is in custody since
no matter
Anticipatory
regular
no जानी पड़ जाते हैं कितना Anticipatory the petitioner is apprehending arrest सब तरफ order change करिए पूरा ना the petitioner is apprehending arrest in connection with such and such case. The prosecution case, as evident from perusal of the FIR, lodged by one
Surendra Muduli.
Surendra Muduli, Diano, and Badani Muduli. Is that the petitioner, from her husband, and one Hari Behra dragged their son, Ajay Muduli, to the house, to the road from his house and assaulted him by means of iron rod and bamboo stick, causing bleeding injuries on his head. When the informants rushed to the spot to rescue their son, the culprits also assaulted them. In the meantime, being thus humiliated, the deceased drank poison and died. It is submitted by Sri Doral, counsel to the petitioner, that the affair story is completely false and baseless, as would be evident from the postmortem report, from a copy of which has been filed by him. The result of the postmortem report reveals that the autopsy surgeon did not find any external injury on the deceased, which prima facie negates the allegation of assault on the head of the deceased by means of iron rod. In view of such contradiction, in view of such discrepancy, it is difficult to prima facie accept the prosecution case as laid to be true. Stop. However, considering the severity of the allegation, while not being inclined to grant anticipatory bail to the petitioner, surrender releasable.
Oblige, Your Lordship.
So item number 49.
May I please, Your Lordship? My lord, in this case, my lord, kindly have a glance at Annex 6, my lord, page 49, my lord. With due permission of the Lordship, I am reading, my lord.
Go through. You're 376.3.
My lord, the petitioner, number 1 and 2, my lord, father and mother, and the petition number
Hey, what
3,
is
my lord,
the-
is the, my lord, unmarried sister. my lord.
Charge sheet under section 363, 366, 17 books.
What is that higher offense?
Might.
My lord, I may to make submission.
It is not a change in circumstance, not just a change in circumstance. You are on bail, in regular bail. So another application under for anticipatory bail will not lie. That is first. Second, in view of Pradeep Ram, you have to approach the same court. You have to approach the same court and move an application for bail.
My lord, an observation.
Yes, observation I can make. I can make many observations.
My lord, the petition number 1, old man, my lord, the petition.
In the event of arrest, he shall be released. That order cannot.
That order cannot. I can only make an observation that you can make an application that will be considered.
Consider this shall be released on bail, my lord, because the petition number 1. My lord.
आपने पॉइंट लॉ टाको मोटे धरू ना देगे लॉ टा जाची से अनुसार करिबा ना नहीं मिस्टर बेरा ना लॉ बियॉन्ड लॉ जाके ई ऑर्डर तो मैं ना ये पूर्व केस पास करली अपन केस कहीं पास करे को मना
My
कर
lord, law is well settled, my lord. A person once released on bail, my lord, unless and until.
अपन से एडिशन वाला पढ़ी ना थे अपन किंतु कहउछन you have not read Pradeep Ram, you have not read my judgment. कौन करिया I gave you an opportunity yesterday. I asked you to specifically go through those judgments so that you will be able to assess the court better. Anyway, I'll dispose of granting him that liberty. The present application for anticipatory bail has been filed by the petitioner. By the petitioner, joined na diyo no?
Tini jana.
By the petitioner.
Mother, unmarried sister, my
By
lord.
the petitioner.
So without going through the, without going to the legal aspect of the matter, my lord, my humble submission, well, in the event of their appearance, they may be released on
No,
bail.
no. That order, I'm sorry, I cannot pass. It will be an illegal order. I cannot pass an illegal order. I can only observe. I can make certain observations which will help you. But you can only make an application that will be considered. That is the only order that I can pass. Will be considered. ଆପଣ ଦେଖୁନାହାନ୍ତି ମତେ ସେ ଲଟ୍ ଅଫ ଜଜମେଣ୍ଟ ଟାକୁ ଦେଖୁନାହାନ୍ତି ଆପଣଙ୍କୁ ମୁଁ କାଲିଠୁ ଆଜିକୁ କାହିଁ ରଖିଲି ଆଜ୍ଞା ଏଇ ଅର୍ଡରଟା ପାସ୍ କରିବାକୁ କଣ ଗୋଟେ ବହୁତ ବଡ କଥା ଲାଗୁଛି ନା କଣ ଆପଣ 366 ଇଟ୍ସ ନଟ୍ ଅ ବିଗ୍ ଇଶ୍ୟୁ
ସରେଣ୍ଡର ଚେ ମୁଁ ଆପ୍ଲିକେସନ ମୁଭ୍ କଲେ ବି ରିଲିଜ ହେଇଛି
ତାଙ୍କୁ ବୋଧେ ସମନ ହେଇଛି କେବଳ
Again, they have been summoned for appearance.
no warrant has been issued. So in Pradeep Ram, in my judgment I have discussed there are 4 options. The court may either cancel the bail
or the prosecution may file an application for bail.
The prosecution may file an application cancelling the bail,
Right.
or the accused may surrender and say that give me bail for the higher offense.
Right.
3 options. Now what has happened? The prosecution has not moved. Prosecution has not moved for cancellation of that bail,
Right.
or for arrest of the accused. The court has not issued any warrant,
Yes.
and the petitioner has also not approached. So as it is, see the किसी न करियो भी से सेमती रहियो. खाली कोर्ट जाए फिर करेगा. So to be on the safe side, I can make that observation also. The कौन लिखे? Earlier approached this court in a BLAPL number 9081 of 2023. Stop. Said application was disposed of, granting liberty to the petitioners to surrender before the learned SDGM Fulbani in the first hour and to move for bail. And in case of rejection thereof, comma, to move the higher forum for bail in the second hour, which would be was directed to be disposed of on the same day. It is submitted that pursuant to the above order, comma, the petitioners surrendered before the court below and have been released on bail. Subsequently, charge sheet was submitted, adding the offence under section 366 against the petitioners.
And 17 postcodes.
In 366 and 17, section 17 of the POCSO Act against the petitioners. Since these are higher offences than the offence for which than the offence under which the petitioners were initially booked, comma, and the court below has issued summons, apprehending that on their appearance they may be taken to custody, comma, the petitioners have filed the present application. Stop. Para. After noting the facts narrated above, this court is firstly of the view that the prayer for anticipatory bail is misconceived in view of the fact that the petitioners are already on regular bail granted by the court below. That apart, neither the investigating agency, the investigating agency has not sought for cancellation of such bail granted to the petitioners, nor sought for any order of arrest. The court below has also so motu not cancelled the bail, but issued only a summons for appearance. Stop. In view of the ratio of the judgment passed in Pradeep Ram versus so and so, I think Mr. Kalongo, you were appearing in that case?
My lord.
Mr. Kalongo, you were appearing in that case? Can you give a reference to that judgment?
I give it.
Pradeep Ram, it is for the petitioners to surrender before the court below, to appear before the court below and move for bail in respect of the higher offence. Stop. Such being the position of law, comma. On facts, this court observes that the petitioners are, who are they? The petitioners?
In-laws, madam.
Father and family. Mother and unmarried sister of the principal accused Sashikanta Mishra.
The petitioners are the father, mother, and unmarried sister of the principal accused,
Sashikanta
Mishra. So, said Sashikanta, the allegation of sexual assault is against said Sashikanta Mishra.
And she has not uttered it in a single word.
The only allegation against the petitioners is that they had facilitated.
No, my lord. My lord, for that, my lord, the victim has not uttered even a single word.
Allegation of call affair.
They extended cooperation in the allegation.
They had facilitated the kidnapping of the victim. Stop.
But
the victim has also
not stated
anything against the petitioners in her statement recorded under section 161 of CRPC. In such view of the matter, let the petitioners, the ABL appeal is disposed of, granting liberty to the petitioners to surrender before the court below, to appear before the court below, pursuant to the summons issued, and move for bail in respect of the higher offences. In such event, the bail application shall be considered on its own merit, having regard to the observations made in this order. Yes.
So it's on 56.
Mr. Behra, but please go through those decisions. This is my request to you. If you are practicing in the criminal side, you must be thorough with these decisions, particularly when the court asks you, you will not. You must assist the court. You are an officer of the court. Please go through those decisions. Specifically, ଆପଣ କହିଲେ ଆପଣ ପଢିଲେନି ଆପଣ ଜାଣିଥାନ୍ତେ ଲଟା କଣ ବର୍ତ୍ତମାନ ତ ଜାଣିଥାନ୍ତେ ନା ଆପଣ ସେ ସୁଶୀଲ ଅଗ୍ରୱାଲଟା ଆପଣଙ୍କ ମୁଣ୍ଡରେ ପଶିଛି once bail always bail, but that is even this is not an anticipatory bail. Anyway, ଦେଖ
Personal item 56.
I apologize, my lord. My lord, in my case, the legal contention was different, that I was in custody and I was moving for bail in another FIR. That case was delisted from that batch of series of cases.
Okay.
My legal point was different.
Okay. Yes. But this is also one of the cases that I had heard and rendered a judgment.
Yes.
My lord, I'll go through this. ସେଟା ଅଛି ମୁଁ ରଖିଛି କିନ୍ତୁ
Yes. ଦେଖ କେତେ item?
Item 56.
My lord, may it please your lordship. My lord, in this case, on the last occasion, your lordship seeked for the economical status of both the parties. My lord, I've seen her to Papa.
The financial status of the accused and his parents is not sound. On the other hand, John is staying in the house of grandparent. ये भी करियो से भी करियो कौन करा जो तार था तो भीतर था सरकारी खाद्य खाई था गरीब लोक कहीं घर को जो खाया पाइबनी कहीं मैं एठी 3 बेली तो निश्चय मिलियो ना नहीं 3 बेली के 4 बेली मिलियो 4 बेली रात्रि बिस्कुट भी देवे अरे जेल में बिस्कुट दिया जाए कारण 7 लोग खाया दे दिया जाए तो रात्रि भोक करियो बोली से बिस्कुट भी दिया जाए जेल गले से ना जानिबे
It was a love affair, and
you may ask a valid question. Has the court visited jail? Yes, the court regularly visits jail. That is why I understand. As a district judge, I was bound to visit every month.
in my initial days of practice, also I had the occasion to visit for obtaining the bail bond, and just for understanding how it works.
No, inside you have to go around. You have to go around. You have to see many things. Then only you will understand. It's a world within a world. It's not that easy. It's a world within a world. So many.
My lord, he was earlier granted interim bail by this honorable coordinate bench of this honorable court, wherein he was granted bail on the ground that an endeavor has to be made whether he will marry the victim or not because of the interest of the minor child who was born. Taking that thing into consideration, he was released to seek instruction whether he is in a position to marry or not. I have received instruction that he is willing to marry, and what I pray humbly before this honorable court is to grant him at least for some weeks interim bail so that he can ensure that the marriage is that thing is given some effect to. That is the only instruction that I have. That he is willing to marry and the parents.
No, I am willing to grant you interim bail. That is why I called for this report, my lord. But now this report is well, in a way, it is against you, my lord. Against you in the sense that by describing you as a poor person, you will not be able to pay anything for the child. If you don't pay anything for the child, this court will not grant you bail. As simple as that.
My lord, but my lord, if he is released, then my lord, he will work and he will try to maintain the law. That is
no. That will be giving a premium to an offender, sexual offender. As directed, Land State Council has obtained instructions about the economic status of the parties. As it appears, Now, it appears that both the parties are not economically sound. Chetik. Sri Kanungo, Learned Counsel for the petitioner submits that he has obtained instructions from his client that he is ready and willing to marry the victim and would make necessary arrangements for the same if he is released on interim bail for some time. Considering the submission as above, the court below is directed to release the petitioner on interim bail for a period of 4 weeks. List this matter on such terms and conditions. List this matter on first week of July.
First July.
In the week commencing 1st July.
But my lord, she is a minor, so marriage proposal.
Minor.
Court cannot.
No, right now, my lord, she has attained majority. She is 21 years old. my
Okay,
lord.
that I will.
Date of occurrence, she was minor.
ବର୍ତ୍ତମାନ ବାହାଘର କଣ ମନା ଅଛି ଦେଖନ୍ତୁ ସେ ଲେଖିଲେନି ଗୋଟେ କହୁଛି is ready and willing to marry the victim, comma, who in the meantime has attained the age of majority. Yes.
Deep progress. Great.
So right now 59.
Item 59 million. Last
Yesterday he was asking for time.
last one that filed the reply to affidavit filed by Lord Fred Miller. Lord, the IO Miller in another deputed to another district in election duty Miller. So I take some time.
The difficulty is, my lord, this is the remand case, my lord. In the main case, my lord, your lordship granted an interim bail for a period of 4 months to the petitioner, my lord.
Yeah, I'll grant him interim bail.
That order was, yes, my lord.
I will grant him interim bail. You obtain instruction till that time.
Yes.
Yeah. Sri J.J. Patra, J.J. Patra? J.P. Patra. J.J. Patra was another judicial officer, district judge. He retired. So I was suddenly reminded of him. Sri J.P. Patra, Learned Counsel for the OPID, requests for adjournment on the ground that the concerned IO is presently deployed on election duty.
Another district.
In another district. The Mr. Learned Counsel for the petitioner submits that the petitioners submit that they have been granted interim bail as per order passed by this court, by a coordinate bench.
By your lordship.
By me. As per order passed by this court in another bail application. But because of pendency of this case, they are unable to be released. Stop. In such way the matter, let the petitioners be released. On interim bail for a period of 4 weeks. Yeah. On such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. 1. They shall submit their passports. They shall deposit their passports, if any, in the court below. Next. They shall appear before the IIC of Kothana.
EOW.
IIC of EOW Bhubaneswar PS on every Sunday at 10 a.m. and such facts shall be certified so and so. Next, they shall personally appear before the court in session over the matter on each date of posting of the case in between. Without stop. No representation through counsel shall be allowed under any circumstances. Next, they shall not leave the territorial jurisdiction of the court, and no such application seeking leave shall be allowed by the court. That's all. List this matter in the week commencing 1st July 2024.
Oh, please.
The learned counsel for the OPID shall comply with the previous order positively. Connected na?
Both are same, man.
Same. Oh, John is 3, John is 3. You know, item?
So item number 61.
Okay.
63.
Item 61. Yes, none appears. List this matter after vacation.
So item number 63.
63, yes.
Please, my lord.
That's the deposition. So, there.
My lord, this is a case under section 307 and the petitioner is inside the custody since 11/4/23.
Yes.
The commenced and the victim as well as the complainant has already been examined in this case. The very facts of the FIR itself goes to show that the victim intervened the quarrel between the petitioner and his wife, out of which the petitioner being endangered, enraged, attacked the victim. So a case was registered under section 307. Your lordship, may I have supplied the copies of the depositions.
Yes, he called thereafter he came out with one axe from his house and assaulted me on my right head, right cheek, and right leg.
Informant as well as injured. They stated
assault,
man.
Injured para 3, your lordship may kindly have a glance of cross examination.
After about 1 to 2 blows from the axe by the accused, the informant arrived at the spot. I was not completely senseless when the informant arrived. So what?
Informant asked me the name of the assaulter and I disclosed the name of the accused. Moreover,
so how does it help you?
Moreover,
Wait, answer the question first. How does it help you?
My lord, my humble submission at this juncture is the entire act is out of sudden provocation. If your lordship would consider, the entire act is of sudden provocation. I bow down to that effect, what your lordship had asked, but the entire case is of sudden provocation and which has been attributed by both the petitioner, both the witnesses.
A clear case of conviction.
Yes, my lord.
Clear case of conviction.
6 injury, lacerated.
11/4/2023, my lord.
11/4/2023. So the injured has been examined. I will grant him interim bail for some time. Yes. Or since the injured has been examined, so no danger.
Informant both.
The petitioner is in custody since
11/4/2023.
11/4/2023 in connection with such and such case. The prosecution case is that the petitioner was quarreling with his wife. Stop. At that time, the injured, who is the wife of the informant, intervened. Stop. Being enraged by such intervention, the petitioner assaulted her by means of an axe, causing injuries on her head, right cheek, and right leg. Learned counsel for the petitioner, referring to the depositions of the informant and the injured, has attempted to point out several contradictions and discrepancies in the evidence. Stop. He further submits that the petitioner, having been in custody for more than a year, and the injured having already been examined, he may at least be granted interim bail for some time in order to meet the urgent necessities of his family. Stop. Considering the submissions as above and the materials on record, while not being inclined to grant regular bail to the petitioner, comma, the bail appeal is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months. Yes.
So right note 66.
May I please? Yeah, after 9 months, the FIR has been lodged, my lord. Occurrence 38/2022. FIR was lodged 14/5/2023. The deceased, my lord, staying in my house. Thereafter, there is a love affair between. All on a sudden, he left my house and committed suicide. And charge sheet submitted, my lord. Petitioner is a 20 years young boy, custody since 15/5/2023. And charge sheet submitted in the meantime, my lord, on 12/7/2023. One year he is in custody.
So the informant is the father of the
Yes, madam.
victim.
Yes.
You said something about deceased. Who has died?
The victim was died, my lord.
Victim committed
Died.
suicide.
Committed suicide coming in the front of the train, my lord. For which if
Oh, because she became
Yes,
pregnant.
victim and she was also
20
pregnant
years
having
boy,
male
madam.
child.
There is
the
a affair
DNA report
between them,
also-
my
That OMP area, that laborers. Yeah.
direct evidence. ये evidence तो देखिए आपने आपने क्या व्यस्त हो जैसे साइको क्लियर होने की मुझे
In 82,
yes.
and in 82, that similar case, no, same case.
The same part.
ये देखिए up to date case भी obtained. List this matter.
We commencing 8th July.
Huh?
8th July.
8 July. We commencing 8 July. Then
227. So right now 69.
And please, Your Honor. The petitioner is in custody since 23rd May 19 under section 302 34 of IPC.
you have the deposition.
CD is required.
Deposition, my lord, I have-
Here also CD is not there.
Yeah, the deposition is there.
Deposition I filed, my lord, annex of 2.
Deposition is there.
Yes,
Is diary required? What is the FIR? Let us see.
PW1 is the post occurrence witness and PW2 informant is the eyewitness.
Eyewitness only.
Okay, who is the eyewitness?
Wife of the deceased, my lord.
What is the allegation?
Allegation, my lord. 3 accused persons assaulted one by deadly weapon.
କଣ ଲେଖିଲେ ଗ୍ରାମରୁ କାମ କରିବାକୁ ଯାଉଥିଲୁ ଠିକ ସମୟରେ ଗୁରାବାଡି ସ୍କୁଲ ଆଗରେ ଗୁରାବାଡି ଗ୍ରାମର ରମେଶ ଦଳ ଦ୍ୱାରା ପୀତାମ୍ବର ଦଳ ଦ୍ୱାରା ମହନ୍ତ ଦଳ ଦ୍ୱାରା ୟୁ ଆର ରମେଶ ଦଳ ଦ୍ୱାରା ଆଚ୍ଛା ତିନି ହାରାମଣି କଣ ଟାଙ୍ଗିଆ ଏବଂ ଖଣ୍ଡା ଧରି ସ୍କୁଲ ନିକଟରେ ମୋର ସ୍ୱାମୀଙ୍କୁ ମାରିବା ପାଇଁ ଅପେକ୍ଷା କରିଥିଲେ ସେଠାରେ ମୋର ସ୍ୱାମୀଙ୍କୁ ଅଟକାଇ ଇତ୍ୟାଦି ଇତ୍ୟାଦି କୃଷ୍ଣ ଭୋଗକୁ ପାଣରେ କହି ସେମାନେ ମୋର ସ୍ୱାମୀର ମୁଣ୍ଡକୁ ଏବଂ ହାତକୁ ଥରକୁ ଥର ହାଣିଲେ ଫଳରେ ମୋ ସ୍ୱାମୀ ମରିଗଲେ କ୍ଲିୟର କେସ୍ ମ୍ୟାଡର କଣ କହିଛନ୍ତି ଦେଖିଆ
PW2
ଛକିକି ଥିଲେ ନା
Vishnu Gowda.
Out of 11 charge sheet witness, only 5 witnesses have been examined.
within 5
At that
minutes.
time, accused person, namely Ramesh, Pitambara and Mahanta were hiding before the school wall. The accused person collectively assaulted my husband by Tangia. When I tried to rescue him, they also chased me, for which I went back to my house. My husband died at the spot.
Direct evidence, sir.
Yes, ma'am.
Expedites trial.
The petitioner is in custody since
23 May 19.
3 May
23 May
23/5/2019. In connection with such and such case, it is alleged that the petitioner and two other persons, owing to previous enmity, killed the deceased by assaulting him with deadly weapons like axe. Stop. In the meantime, some witnesses have been examined, including the wife of the deceased, who incidentally is an eyewitness. Stop. From the copy of deposition of the from the copy of her deposition available in the case record, it is seen that she has vividly described the occurrence and specifically deposed that the petitioner and the co-accused persons were lying in wait for the deceased, and upon seeing him, they collectively assaulted him. Para. In view of such overwhelming evidence showing the complicity of the petitioner, I am not inclined to allow the prayer for bail, which is therefore rejected. Stop. However, the petitioner being in custody for nearly 5 years, the trial court is directed to expedite and conclude the trial as early as possible, preferably within a period of 4 months. Stop. It shall be open to the petitioner to renew his prayer for bail if trial is not concluded within the aforesaid period.
So right now 82. Madam, that 68 and 82.
Same.
One act is valid. But same offense. But two cases was registered in different
In the
police
present
station.
case, as many as 9 witnesses have been examined, but they have not stated anything about the occurrence. Due to suspicion, he has been arrested.
My lord, in one, in 82, my
I have filed the deposition copy in this case.
82, the deceased, he is working in a hotel. He has lost affair. And in 68, one outsider who is in a morning walk, he has lost affair. That affair was transferred to this Chowliaganj case, my lord.
He has seen only before that cardiology department that injured was lying.
So incident is same.
What is the report? Okay. "23 more witnesses remain to be examined. We'll take it up after along with the other case. List this matter in the week commencing 8 July. Up to date case diary be obtained.
Case
Yes.
There is there.
But
But only PM.
The
Along with that
report
case.
be obtained.
along with that case.
Along with ଏକାଠି ଆମେ ଦେଖିବା।
ହଁ ଦି ଯାକ ଏକାଥରେ।
ନା ଏକାଠି ନ ଆସୁ ଆମେ ସିଧା ଲିଷ୍ଟ ସେଟା ବି ରହିବ ଏଟା ବି ରହିବ ଦେଖିଦେବା କଣ? Yes.
So right now 85.
My lord, in this case, deposition, I have submitted the deposition.
Deposition kahin dekhe?
Deposition of 4 witnesses. PW1, PW2, PW3, PW4. PW1, we don't speak about the occurrence or assault by the accused person. And PW2 has stated that I don't know anything regarding this case. PW3 has stated also, I do not know anything regarding this. PW4 is a witness to the TI period. He has spoken that I was examined by police regarding this case many times. I cannot recall whether I have stated
Yes.
the police.
Madam Vibhuti Mishra, he was Vibhuti Bhushan Bhanjadev. He was examined.
Nine. He has not been examined.
He is the eyewitness and he is also identified that present accused person in
He is not an eyewitness. The police brought the accused person before him, and before him, the accused person confessed before police. He is not an eyewitness.
Your lordship call for a report from that officer that way how the
Your Honor,
hearing was conducted. Now he is claiming that
বিভূতিভূষণ বন্দ্যোপাধ্যায় এটা হচ্ছে পবিত্র ন্যায়।
No, sir. I have gone through you have made that submission. I have gone through the test identification report where the magistrate concerned has given in detail how it was conducted.
ନାଇଁ ନାଇଁ ସାର୍ ମୁଁ କହୁଛି ପରା ସେ ଯୋଉ ଇଏ ଟେଷ୍ଟ ସାର୍ଟିଫିକେଟ ବାବଦରେ I saw the accused person again in police station after 3 days of the on that day, the police called me to the police station. The police identified to the accused person to me. এটা হচ্ছে statement of
देखले अपन टेस्ट आइडेंटिफिकेशन पैरेटा देखले we'll take it up tomorrow.
state identification parrot
TI parrot report is available.
তার 161 statement টা ওটা এটা স্যার
No, TI parrot আজ্ঞା ସେ କଥା ସେ ମ୍ୟାଜିଷ୍ଟ୍ରେଟ ଙ୍କ ପାଖରେ କହି ପାରିଲାନି TI parrot ତ ମ୍ୟାଜିଷ୍ଟ୍ରେଟ ଲିଖିছে ନା
ନାଇଁ এটা স্যার ডিপোজিশন যা ଦେଇଛି I saw the accused person again in police station after 3 days. On that day, the police called me to the police station. The police identified to the accused person to me. এটা কইছি তারপরে তার ইয়ে কইছি তার এভিডেন্স রে কইছি যে I saw the accused person at the occurrence, but I have not seen the full body of the accused person. Para 6 রে I cannot say the dresses of the accused person at the time of occurrence. I have not remember which accused was holding which weapons. এটা কইছি and it was the কইছি it was dark. There is no light.
What has that Vibhuti Mishra said?
Well, Vibhuti Mishra, he has identified the TI parrot and in 164 statement, my lord.
The police brought the accused person before me.
ମୋର ନାମ ବିଭୂତି ଭୂଷଣ ଭଞ୍ଜଦେଓ ମୋ ଘର ସାମ୍ନାରେ ଭାରତ ଫାଇନାନ୍ସ ଅଫିସ ଅଛି ସେଠାରେ କାମ ପିଲାମାନେ ପ୍ରତିଦିନ ପ୍ରାୟ 10:30 ରୁ 11 ସମୟ ଭିତରେ ଚିତ୍କାର ଓ ପାଟି ଶୁଣିଥିଲି ଏହା ଶୁଣି କୁଆଡେ କଣ ହେଲା ବୋଲି ଦେଖିବାକୁ ପାଇଲି ଯେ ଭାରତ ଫାଇନାନ୍ସ ଅଫିସ ନିକଟରେ କଣ ଠେଲାପେଲା ହେଉଛନ୍ତି ଦୂରରୁ ଜଣା ପଡୁଥାଏ ଏକ ଝିଅକୁ 2 ଜଣ ପୁଅ ପିଲା ଧରିକି ଠେଲାପେଲା କରୁଛନ୍ତି ଏହା ଦେଖି ମୁଁ ତାଙ୍କ ଅଫିସ ଆଡକୁ ଧାଇଁ ଗଲି ଯିବା ବାଟରେ ଜଣା ପଡୁଥାଏ 2 ଜଣ ପିଲା ମଧ୍ୟରୁ ଡେଙ୍ଗା ପିଲାଟି ଝିଅର ହାତ ଧରିଛି ଓ ଗେଡା ପିଲାଟି ପଛପଟରୁ କୌଣସି ଏକ ଜିନିଷରେ ଝିଅର ପଛପଟୁ ଆକ୍ରମଣ କରୁଛି ସେ ଝିଅ ନିଜକୁ ବଞ୍ଚାଇବା ନିମନ୍ତେ ସେ ଧରିଥିବା ଲୋକରୁ ନିଜକୁ ଛଡାଇ ଇଆଡେ ସିଆଡେ ଦୌଡ଼ିବାକୁ ଲାଗିଲା ଏବଂ ଆସି ଅଫିସ ଗେଟ୍ ସାମ୍ନାରେ ପଡିଗଲା ଏହି ସମୟରେ ସେ ଅଫିସରୁ ମଧ୍ୟ କିଛି ଲୋକ ବାହାରି ଆସି ଗେଟ୍ ଭିତରେ ପାଖରେ ଠିଆ ହେଲେ ଓ ସେଇ 2 ଜଣ ପିଲା ମଧ୍ୟରୁ ଗେଡା ପିଲାଟି ଏକ କାଠ ଫାଳିଆ ଉଠାଇ ସେଇ ଅଫିସର ଷ୍ଟାଫ ମାନଙ୍କୁ ଦେଖି କଣ ଗୋଟେ କହିଥିଲା ଏବଂ ପଥର ଉଠାଇ ସେ ପଡିଥିବା ଝିଅ ମୁଣ୍ଡକୁ ଛେଚିଦେଲା ଏହି ସମୟ ଭିତରେ ମୁଁ ଆଉ କିଛି ଜଣ ପାଖକୁ ଯାଇ ପହଞ୍ଚିଲୁ ଏହା ଦେଖି ମୁଁ ପାଟି କରିବାରୁ ସେଇ 2 ଜଣ ଲୋକ ସେଠାରୁ ସେଇ ଅଫିସ ପଛ ଆଡକୁ ଦୌଡ଼ି ପଳାଇଲେ ଏବଂ ମୁଁ ମଧ୍ୟ ତାଙ୍କୁ ଗୋଡାଇଥିଲି କିନ୍ତୁ ଅଫିସ ପଛପଟେ ଅନ୍ଧାର ଥିବାରୁ ସେମାନେ କୁଆଡେ ଗଲେ ଜାଣିପାରିଲେନି ପରେ ଜାଣିବାକୁ ପାଇଲେ ଯେ ସେମାନେ ଅଫିସ ଗେଟ୍ ବାହାର ପଟୁ ଦେଇଥିବାରୁ ସେଇ ଅଫିସ ଷ୍ଟାଫ ବାହାର ପଟକୁ ଆସିପାରିଲେ ନାହିଁ ଏଇ 2 ଜଣ ଲୋକଙ୍କୁ ମୁଁ ଆଗରୁ କେବେ ଦେଖି ନାହିଁ କି ଚିହ୍ନି ନାହିଁ କିନ୍ତୁ ସେଦିନ ଘର ପାଖରେ ଆଲୁଅରେ ମୁଁ ତାଙ୍କ ଚେହେରା ଦେଖିଥିଲି ଓ ପରେ ଦେଖିଲେ ମୁଁ ତାଙ୍କୁ ଚିହ୍ନି ପାରିବି and he has identified the
Identifying person is Pavitra Kumar Naik.
ତାର ମୁଁ ପୁରା ପଲ୍ଲୀ
Not Vibhuti Mishra. Identification जो TI parrot report ଅଛି ସେଟା ପବିତ୍ର କୁମାର ନାୟକ ଅଛି
ବିଭୂତି ଭୂଷଣ ଭଞ୍ଜଦେଓ he has not identified
report. There may have been another report also, but this is one report which they have sent.
Sam Kedia and Alai Cheru and petitioner. He was identified by the present petitioner. And from the spot, my lord, that knife was seized. And Pavitra Naik is the office staff, my lord.
This petitioner was not holding any arm. No overt act has been attributed to this petitioner.
Pavitra Naik in 164 statement.
Pavitra Naik already has been examined. That deposition is actually 164 value kono. That para 6 re last paragraph re koichi pora. On that day, the police called me to the police station. The police identified to the accused person to me. It para 6 ro last line da. তার আগুরু কইছি যে I cannot এই যে I
Yes,
I
Mr. Mishra.
I have not seen the full body of the accused person.
That day they called me to the police station, the police identified to the accused persons to me. So this loses, so in view of this admission, the TI parade report loses its sanctity, isn't it? What other, yes, sir, ठीक है, automatic, sir, what other evidence is there?
164 statement of the Pavitra Vibhuti Bhushan statement. I have 161. I have my lord that he has seen they were played away and the knife was seized from the spot. And another employment that Monjo Devi.
What is the motive for?
My lord, there is a love relationship between the deceased and another person.
Another person, whom?
My lord, Osuni
They were living
Agent
as a,
petitioner Osuni Sanda. He has love relationship with that lady.
they were living as a husband and wife. তারপরে তার
And PM report is also that vital organ of neck, injury due to vital organ of neck.
that I do not dispute. PM report বাবদে I have got no dispute. কিন্তু কথা হচ্ছে যে this person was not armed with any weapon and know what
Let that Vibhuti Bhanjadev be examined.
My lord, that he may be examined.
Let us wait, let us keep it on.
know what has been attributed to the CORAM. Apart from that, sir, যে I cannot say the dresses of the accused person at the time of occurrence. I have not seen the full body of the accused person. তারপরে this accused person became senseless. আমি যদি human probability.
No, I'm not on Pavitra Naik. Let us forget about Pavitra Naik. Since you have pointed out that he admitted that police had identified the accused to him, so his that TI parade evidence goes. But that Vibhuti Bhanjadev, let him be examined. You wait.
The case has been fixed on 11 of this June for the evidence of Vibhuti Bhushan Bhanjadev.
Oh, so let him be examined. 11th for the matter pending thou.
I have got the information from the sister of the accused that Vibhuti Mishra, Vibhuti Bhanjadev is demanding money over telephone that I will report against you.
That is false.
So you file an affidavit in the court below. The court will take cognizance of it.
I will bring out from the cross examination from him in the event of his examination.
I think I'm keeping it pending. I'm not disposing of. I'm keeping it pending. We'll take it up after 11th June.
Yes, sir.
All right. আমি তাহলে এটা 24th June রে নেব হ্যাঁ this matter in the week commencing 24th June since it is submitted that one of the eyewitnesses, namely Vibhuti Bhushan Bhanjadev, is likely to be examined on the next date, it would be proper to wait for his examination. Stop. The court below is directed to transmit copy of the deposition of said witness after his examination. Stop. Place this matter in the week commencing 24th June. Yes.
So right now 88. Yes. It may be taken over
After vacation.
So right now 89.
89.
Yes, ma'am.
Yes.
The prisoner who your lordship with the husband in custody since 10/5/2023. Their marriage in question was solemnized way back in 2009. They're blessed with 2 children. And here the date of occurrence is 24/2023. Allegation that on the date of occurrence, the prisoner left 2 of his children in his sister's house, and thereafter allegation of assault.
PW2, the brother of
8 to 9 witnesses be examined. I have supplied the copy of the deposition.
Deposition copy.
PM is that aspasia due to throttling. But what he has done, he has made
नहीं, ये जो लिखा है, I found that my sister was killed by pressing of neck, but after her death, poison substance was poured on her mouth. How did he know?
ମାନେ ଏମାନେ ଯେତେବେଳେ ଗଲେ ଦେଖୁ ତା ପାଟିରୁ ମାନେ ବାହାରୁଥିଲା ପଏଜନ ଇଏ ଶୁଙ୍ଗୁଥିଲା
ସେଟା ତାଙ୍କ ଓପିନିଅନ ନା।
କିନ୍ତୁ ତାପରେ ଆକ୍ଚୁଆଲି ଥ୍ରୋଟଲିଂ ପିଏମ ରିପୋର୍ଟ ଇଜ
ସେଇଟା ଦେଖିଆ। Accused was assaulted by demon. I found that my daughter was killed by pressing of soda. ये unless you have seen, you cannot give an opinion. You are not an expert. Doctor can give an opinion.
Doctor
can give an opinion.
Doctor has given opinion.
Doctor कौन କହିଛନ୍ତି?
That totally.
अच्छा, so what is your explanation? How did your wife die?
In fact,
there must be some explanation.
Yes.
You have to give an explanation. This is
marriage in question was taken 2009.
2009 means 304B হবনি। 302 হবো।
No, 302 is there.
304
290 302 and the 34 IPC is there.
302 ରେ ଚାର୍ଜ ସିଟ୍ 304
କଣ ପାଇଁ ସେ ମାରଲେ?
ତା କ୍ୟାରେକ୍ଟର ସସ୍ପେକ୍ଟ
Character suspect କରୁଥିଲା ଯେ that he is having relation with somebody else.
ନେଇକି ଛାଡିଲା ବାପ ଘରେ
ତା ଭଉଣୀ ଘରେ।
ତାପରେ ଭଉଣୀ ଘରେ ତାପରେ ଆସିକି ତାକୁ ମାରିକି ପୁଣି ଗଲା ଯାତ୍ରା ଦେଖିବା ପାଇଁ ତା ମୁହଁରେ ପକେଇ ଦେଇଗଲା।
କେବେଠୁ ହେଲାଣି?
10/5/2023.
5/23
ଆଉ ଦେଖିଆ ଭ୍ୟାକେସନ ପରେ ଆସୁ।
3 ମାସ ଖଣ୍ଡେ ତାର mother is seriously mal. Children is there and mother is there.
ଛୋଟ ଫାଇଲ ନା ଇଏ? କେହି ସାକ୍ଷୀ ପାଖି ହେଇନାହାନ୍ତି?
9 ଜଣ ସାକ୍ଷୀ।
ଆଉ କିଏ ଅଛନ୍ତି ମେନ୍ ସାକ୍ଷୀ?
ମାନେ ଅଛନ୍ତି
ଇନଫର୍ମେଣ୍ଟ ହେଇଛି PW2
ଖାଲି ଇନଫର୍ମେଣ୍ଟ
brother of the deceased.
ଆଉ ଜଣେ ଅଛି ସରପଞ୍ଚ ପୁରୁଷୋତ୍ତମ ଭୋଇ
ସେ
ମାନେ ଆଉ ଏଗୁଡା କିଏ ଦେଖି ନାହାନ୍ତି ବଟ୍ ଓନ୍ଲି ସମ୍ ଭିଲେଜର୍ସ ହାଜ ଗିଭେନ୍ ଷ୍ଟେଟମେଣ୍ଟ let some other material witnesses be
let 2-3 ମାସ interim mail ଦିଅନ୍ତୁ, let it lie over. In the meantime I will old mother ଜଣେ ଅଛି, 2ଟା minor children, no other person is there.
The petitioner is in custody since
10/5/2023.
10/5/2023 in connection with such and such case. It is alleged that he killed his wife by throttling her neck and projected it as an act of suicide by pouring poison on her mouth after her death. So, learned counsel for the petitioner submits that the mother of the petitioner is old and ailing. Moreover, 2 of his children are presently residing with her mother. With her mother, so?
Yes.
He therefore pays for grant of interim bail for some time. Considering the submission as above, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 4 weeks. On such terms and conditions, list this matter in the week commencing 24th June. Yes.
Much it.
So
item number 93.
Is the last? Yes.
My lord, here petitioner is languishing in the jail custody from 7/10/2023, my lord. In the meantime, investigation has been completed, charge sheet has been filed, my lord, and your lordship has also granted bail to the enlarged member and also narrated.
You are the husband?
I am the husband.
Yes,
My lord, case is
charge sheet
submitted. Your lordship has observed that. Your lordship has observed that by bolting the door from the inside, she has committed suicide, and the family, entire neighborhood, they have categorized there is no dispute, no nothing, my lord, no yet. That's why, my lord, 306 has also not been inserted in the charge sheet, and there is no direct allegation there in 302, my lord. And my lord, your lordship has observed in the bail order also, my lord. Your lordship
will take it up after vacation.
And all the neighborhoods.
In fact,
there is no
independent witness has supported the prosecution.
Yes, my lord.
None of them.
None of them.
But why she will commit suicide within 4 years of marriage, having 2 years of child?
And they have also not stated, they have categorized all the, my lord, neighborhood stated there is no such dispute, my lord.
Let it come in the reopening.
My lord, your lordship,
Yes,
interim bail,
no.
because your lordship has, and there is no external injury.
No.
And your lordship can see there is no, your lordship has also.
304 is 4 years of marriage.
And nobody has stated that all those. Hon'Ble lordship, it's a ଛୁଆଟା ଙ୍କ ଘରେ ଅଛି ଛୋଟ ଛୁଆଟା ଅଛି ଙ୍କ ଘରେ ଅଛି 4 weeks ଦେଲେ ଛୁଟିରେ lordship ବର୍ଷେ ପାଖାପାଖି ରହିଛି lordship
Please this matter in the week commencing 24th.
lordship interim
No,